Supplementary list for pronouncement of judgment. Item 22 and 23.
My lord, I appear on behalf of the petition.
In such circumstances, we have no hesitation in holding that Article 11, Schedule 1 of the Court Fees Act 1870, Assam Amendment Act brought into effect by the Assam Court Fees Act in respect of the levy of court fees for grant of probate or letter of administration at the rate of 7% ad valorem, where the value of court fee exceed 5,000 without there being any upper limit, is ultra vires to the Article 14 of the Constitution of India, and same is held as such.
Much obliged.
Yes.
For pronouncement of judgment, item 24.
In view of the above discussions, we are of the opinion that the order passed by the learned single judge is not liable to be sustained for the reasons indicated above. Therefore, the writ appeal is allowed. The impugned order dated 5/4/2019 passed by the learned single judge is set aside, and the writ petition filed by the private respondent is dismissed. However, we make it clear that this order would not preclude the private respondent from raising any claim in respect of land in question based on title, and the writ petitioners, private respondents are free to avail appropriate remedy under the civil law if so advised.
Item number 1. Huh? No need.
Yeah, please, Your Lordship. Item number 9. Perhaps Your Lordship may not like to take SP Bhattacharya will appear for the.
Another bench.
Similar to in respect of the item number 18 also.
18, she is appearing.
Yes.
Another bench.
Yes.
I'm sorry, Your Lordship, I could not mention item number 2 when it was called. I beg to mention item number 2, Your Lordship.
Yeah.
Item 2.
Yeah, what do you?
Yeah, we have some difficulty to take up the matter. The arguing counsel, Mr. B. Bora, he is out of station, my lordship.
But in this matter, some matter is pending before the Supreme Court.
Lordship, I have come across that order,
Yes.
Honorable Supreme Court's order. The matter has been disposed of on 21 to 2024 as not raised, Your Lordship. But however, question of law, if any is left open, Your Lordship, you can have it. Sir. This matter relates to maintainability of authority application to juveniles, my lord.
Then we have to decide it.
Yes, ma'am. Let the matter come up for hearing.
Is submitted by the party bench. Matter regarding maintainability of the anticipatory bail application under section 438 CRPC. In the cases of juvenile was pending before. Now the Honorable Supreme Court in special leave to appeal criminal numbers 12659 of 2023. However, the said SLP has been dismissed as disposed of as not pressed by the order dated 21st of February 2024. Stop. In such circumstances, the matter is required to be heard by this court only. Admit parties are already represented, hence no need to issue formal notices, just for hearing in due course.
Highly obliged.
May I please, your lordship? With the consent from the other side, I beg to mention item number 7.
7.
Oh.
And the confidential report is already there. You raised the issue regarding release of water in a particular area in 2018. Now, what remains in this matter?
Lordship, some personal difficulty of senior counsel.
What remains in this matter? That's right, personal difficulty, but what remains in this matter now? In 2018, some flood was there on account of release of water. Now, at present, if there is any mechanism to control that, we have to see. Otherwise, what remains in this petition? Let the number comes. Then it comes.
May I please, your lordship? I am appearing on behalf of M. Bhagavati. With the consent of the other side, I beg to mention item number 12. He has some medical emergency. His wife is in dialysis today. Matter may come after 1 week.
Last day, on 4/10/2023, you were directed to complete your instructions, whether you are interested in making those persons party respondent who have already been promoted or not. So if you are interested in making them party, then we'll proceed further. Otherwise, there is no, how can we proceed further?
Lordship, kindly fix that Friday.
The court has the basic grounds ought to be ventilated in this writ petition that owing to the question amendments made in the rules of 1963, the petitioners who were initially appointed as ordinary gate required to pay 8 years of service before they could consider for promotion of JA. We feel that in case the relief is sought by the petitioners and the writ petition is extended, it would change the seniority position of those candidates who have been directly selected, promoted on the JA in the intervening period. Mr. Bhagavati, learned concept for the petitioner prays for time to find out whether the petitioners are desirous to implead such persons or not as party respondents. So you have to either inform if you are not interested in impleading those persons, will dispose it of this petition.
Lordship, just 2 days, fix on Friday. Lordship.
Have a telephonic instruction come back to us when the matter is called. Only on that point. Ask Mr. Bhagavati. Only on that point.
Interested, then it's okay. Otherwise, why should we go? Yes.
Lordship's permission, item number 19, madam. Mr. HMO was arguing the matter is not available today. Could it be after a week, madam?
You are for
Madam, I found the petitioners, madam. Petitioners, madam.
petitioners, who is from the state. So on 13/5/2022, the court has passed an order to the state government to look into the matter for enhancing the honorarium or something. What do you, what are your instructions on that? Almost 2 years have passed. The stand of the IOCL was that if the state government asks us, will enhance the,
We have filed an affidavit, my lord.
where is that?
Page 56.
This production, man.
Sixth paragraph.
From earlier 80 to lordship, now they have increased to 100 rupees.
For the
100 rupees.
Yes, that was filed, the affidavit is filed on 23rd of June 2023 by one Nitul Gogoi.
Yes. IGP, my lord.
They say they are considering it for 100, but my lord, the minimum wages act, my lord, that even if you go by that, it comes.
Ultimately, you can't claim on the basis of minimum wages. It's a voluntary service.
Exactly, my lord.
That you can't claim.
To some extent, my lord, that is correct, but otherwise, my lord, we are not just doing the work of a VDP. Admitted position is they give us a detailed duty to work with CISF personnel throughout the day.
Ultimately, we have to go by the scheme.
My lord, that
Now, your appointment on contractual basis or in any other manner can't be treated
the
in that manner, sir.
the admitted position is that they made a selection, they have taken selected persons to work in that particular field.
That's very
To some extent, my lord, perhaps the argument would be on the basis of Nihal Chumara. I am not prepared today with the arguments because Mr. Choma was looking in the file. He has some difficulty today. If taken up on the next week, my lord, perhaps we can have some.
Once they have announced your, earlier it was 30 rupees or something.
My lord, 86, from 83 rupees, they have brought it up to 100 rupees.
Then what else? They have, ultimately, it's a voluntary service. Don't do it.
My lord,
Okay. They wanted, and this situation now may have even come up.
Wisdom.
Tuesday,
But 21st, Lordship is fixing 21st.
complete your instructions, yes.
Lordship is fixing it on 21st.
Tuesday, whatever the date may be.
Next week.
No.
Obliged.
Yeah, please, your lordship. I'm paying for listing and IA in connection with late appeal. The appellant,
When?
day after tomorrow,
Not day after tomorrow, next week.
can fix a date.
You ask the court master, he will give you the date.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 11 of today's daily list. The conducting council B Pathak is out of station.
You do one thing, with the consent of the parties, you draw an order and give it to us, we'll sign it. Do one thing. We'll do this every time with the consent of the parties, then you get yourself agreed on a particular order, we'll pass that order.
Maybe around that. Voting करना शुरू करें उसके बाद फाइनल कंक्लूजन
We fail to understand how this BSNL is agreed by this order. Have you gone through that order? How the BSNL is agreed by this order of the CAT? What are the directions? Was the occasion for the BSNL to file this petition? On what ground? How this order is adverse to you? You are both,
I am not in this matter.
who is the counsel?
Respond.
B Devi.
Where is she? Call her. And the number will come and we'll see.
Lordship, in item number 5, Lordship, we had filed one additional affidavit on 10th, Lordship. It may be allowed to be called for, Lordship.
Daily list for orders item 1.
This review petition is filed reviewing the order dated 21/2020.
What's the illegality in that
20.
order?
My lord, that the respondent number 2
Yeah.
who conducted the case, he was not aware at the time of that the clarification notification of his memorandum was.
What was the,
Yeah.
what is the clarification in that notification? The same is, same thing is reiterated?
No, not saying, my lord, there is put
What was the clarification?
Oh.
Just, tell us.
clarification at page 14, my lord.
Page 14.
Page 14, this is the clarification office memorandum
Yes.
22/10/2019.
Yeah, what is the
And
clarification?
clarification para 9, clause 9 and 10, my lord.
Yeah.
Next page, my lord.
Para 14. Page 14,
Page 15, my lord, it is a relevant page,
page 15.
clause 9.
Yeah. Regular service.
Regular service for the purpose of MSCPS shall commence from the date of joining of a post in direct entry grade on a regular basis, either on direct recruitment basis or on absorption or re-employment basis. Service rendered on casual ad hoc contract basis before regular appointment on a pre-appointment training shall not be taken into reckoning. However, past continuous regular service in same and another central government in 2009, central government department in a post carrying same pay level in the pay matrix prior to regular appointment in a new department without a break shall be counted to our qualifying regular service for the purpose of MSCP only. However, the benefit under the MSCP in such cases shall not be considered till the satisfactory completion of probation period in the new post. Next page, my lord, 10. Past services rendered by a central government employee in a state government, statutory body, autonomous body, and public sector organization before appointment in the central government shall not be counted toward regular service.
This was where the,
This is
this clause
and
was,
it is
sir, this clause was very much in the original circular also. This was very much, this clause was very much there. What was the clarification regarding that? This clause was very much there.
regular pay.
Read this order which you are seeking review, 20th of January 2020. Passed by the division bench, read.
Page 9, page 9.
Para number 4.
Para number 4, my lord.
In this context, I
Sir.
would like to refer to the order.
Yes,
Clause
para
9 and
number
10.
regular service. For the purpose of MSCP cell comments from the date of joining of a post in direct entry grade on a regular basis, either on direct recruitment basis or on absorption re-employment basis, service rendered on ad hoc contact basis before regular appointment on pre-appointment training shall not be taken into reckoning. However, past continuous regular service in another government department in a post carrying same grade, same pay, same grade pay prior to regular appointment in a new department without any break shall also be counted toward qualifying regular service for the purpose of MSCP as only and not for the regular promotion. However, a benefit under MSCP in such case shall not be considered till the satisfactory completion of the probation period in the new post. Here, my lord, central government is not there. 3, 4, 5. Fifth line, my lord.
And these people. And the pay of the.
My lord, another pair is that, my lord, they have filed 2 affidavit in this case. And I prepared the reply to the affidavit and forwarded to the department. But the person who handled this case, I could not contact it. But last week, my lord, one person contacted me over phone that he expired, my lord. And that is why we are going to file affidavit, my lord.
There is no question of affidavit. There is a concession on your part in this order itself.
Here, my lord, that,
Read para number 5.
and a 10, my lord.
Para number 5. Yes, 10 is the verbatim same. Which was earlier in the notification, that clarification is verbatim same.
That in view of the
Mr.
provisions
Consul,
extracted
Mr.
above
Consul,
learned.
Mr. Consul, there are 2 problems in this matter. First, there is a concession on your part. And second, the tribunal has decided the case on the basis of a OA of Girbhar Singh. What happened in that? Have you challenged that order?
My lord,
That OA in Girbhar Singh, that order passed by the tribunal on 12/5/2014, whether you have challenged that?
my lord, against that order, my lord, we prefer this repetition here.
Not against that order, sir. Read the tribunal's order, that order, against which you have preferred this writ petition, which was disposed of 20th of January 2019.
My lord, sorry, I have not annexed it. Because it is filed by another.
Page number 18.
Yeah, give them. And it is on the bottom. Beyond, there is nothing. Here, page
77 of my additional. Page 77.
Page number 81.
77, my lord.
The page number 81 of your paper book. This para number 5 of the CAT's order. Tribunal's order, para number 5.
Yeah, keeping in way on this.
Have you gone through the file?
Yes, my lord.
The tribunal's order is 3rd of January 2019.
Yes, my lord. 3rd January of 19.
Now,
At page 77.
page 77, now read para number 5. of the tribunal's judgment.
Accordingly, it is confirmed that the applicant on joining the current department was absorbed, taking into account the period of his past services in the state government of Arunachal Pradesh. So far as counting the past service in the state government is concerned, the case is squarely covered by the judgment of principal bench in the case of Gibbon Singh in the OA number dated 12/5/2015. Keeping in view of the above, the OA is disposed of. The response are hereby directed to grant second MSP if found fit on completion of 20 years of service by counting the period of his service in the state government of Arunachal.
So this order in the Girbhar Singh case, whether the appellants have challenged that order
My
before
lord,
this court or any other forum?
My lord, I'm not, for instruction, I may be
No instruction.
accommodate some
Nothing.
time, my lord.
Okay. This review petition is filed by the appellants seeking review of the order dated 20th of January 2020. Full stop. It is noticed that the counsel appearing for the applicants in the review applicant has made a statement before this court, that the order dated 20th of January 2020, which is now sought to be reviewed, be not treated as precedent. It is also to be noticed that the writ petition number 172/2020 was filed against the order dated third of January 2019, passed by the Central Administrative Tribunal, Guwahati bench in OA number in OA number 040/00104/2016, wherein the tribunal, while relying on the decision of the principal bench of the Central Administrative Tribunal rendered in Girbhar Singh in OA number 2747/2011 dated 12/5/2015, has accepted the claim of the respondent that his past services in the state government are liable to be counted for the purpose of grant of MSCPs. And it counsel for the applicant is not in position to disclose that whether the judgment passed by the principal bench of the CAT in Girbhar Singh was subjected to challenge before this court or any other forum. Stop. In such circumstances, we don't find any case for review of the order dated 20th of January 2020. Hence, this review application is dismissed.
For admission, item 3 and 4.
Right, Your Lordship.
Yes.
Lordships, the subject matter of the instant petition before your Lordships is with regard to the
Jurisdiction of the
jurisdiction of the tribunal, your Lordships, specifically in view of the ouster clause, which was a part of the advertisement which was issued by the authorities. And the conduct of the respondent in not having annexed that particular part of the advertisement only, where the ouster clause was in fact incorporated in the advertisement. Initially, the respondent had approached this honorable court by way of a writ petition, which was
disposed
relegated.
of while
For the-
relegating him to the.
Yes, your Lordship. That is the basic point before your Lordships. Your Lordship, my only submission before your Lordships is that the honorable tribunal, there's no dispute that otherwise the jurisdiction would lie with the honorable tribunal. There's no dispute on that factum. It cannot be, there cannot be any other finding to that effect. However, if there is an ouster clause and if she had accepted that ouster clause as a part and parcel of the advertisement, and thereafter having participated in the advertisement, having gone for the interview as well to Chandigarh to appear in the interview, thereafter having come back and challenged the said thing before the honorable tribunal, and that too without annexing the ouster clause, your Lordships. That is the subject, the only the area of dispute before your Lordships. And in this respect, the honorable tribunal has traversed beyond the powers which are akin to the tribunal, in as much as they have distinguished two judgments of the Honorable Apex Court as well as of the Gujarat High Court, one rendered by Justice M.R. Shah, which is very clear insofar as the facts is concerned. The facts of that particular case, which we have perhaps annexed in my district Zalaka case,
Which is the order of the tribunal, thereby your objection was rejected,
whereby my objection was
rejected regarding jurisdiction.
Lordships. Your Lordships will find that at page 290, your Lordships. This is the starting. It starts at Annexure U, page 290. They have considered all our submissions, and then your Lordships will come to page 310. The 311 actually. So it starts at paragraph 21, your Lordships. This is where they start distinguishing of whatever we had submitted. And at paragraph 22, while considering that case of the Gujarat.
Wait, para number 21. please.
Lordships. During the course of hearing, so-and-so learned envious standing counsel for the respondents has vehemently objected to entertain the instant application on the ground of lack of jurisdiction as per clause 23 of the aforementioned notification. According to so-and-so, similar case of jurisdiction on the point of clause 23 of the pursuant to recruitment drive 2019 was considered by the CAT Jaipur bench wide order dated so-and-so. After perusal of the said order dated 11/1/2023, it is noted that the Central Administrative Jaipur bench has rejected the said OA on the basis of the judgment dated 14/6/2016 passed by the Honorable High Court of Gujarat in the case of Yuvraj Singh Dilip Singh Zala versus Union of India in so-and-so application. The facts of the aforementioned case of Gujarat High Court at Ahmedabad in the case of Yuvraj Singh Zala is that while employment notice number so-and-so dated so-and-so, applications were invited by the Western Railway Recruitment Cell, inviting applications from the eligible candidates of India for various regions, divisions, and workshops of the Western Railway. In response to that, the applicant submitted his application. He appeared in the written examination held on so-and-so date at Gurukul Vidyalaya, Vadodara, pursuant to the call letter issued by the respondents. Thereafter, after verification of the documents, he was sent to the Railway Health Unit for medical examination, wherein he received a communication dated so-and-so from the Railway Recruitment Cell, informing that since no vacancies were notified for the category of OH, orthopedically handicapped, in the said employment notice dated so-and-so, he is not found suitable for any post against the same. Being agreed with, the applicant submitted an appeal before the Chief Medical Director, which was rejected by the authority, wide order dated so-and-so, and being dissatisfied with the aforementioned two communications, the applicant filed OA before the CAT Ahmedabad bench, where the respondents raised objection referring clause 11 of the employment notice dated 27/9/2012, wherein it was mentioned that in case of any dispute, jurisdiction will be with the Central Administrative Tribunal Mumbai and the High Court Mumbai only. In this background, while rejecting the case of the applicant, it was observed by the Honorable High Court of Gujarat at Ahmedabad, inter alia. 403. In even otherwise, we have considered the issue involved in the petition on merits. There is a logic behind clause 11 in the employment notice. As such, it cannot be disputed that both the CAT Ahmedabad bench and the CAT Mumbai bench have jurisdiction to decide and consider the dispute between the parties with respect to the appointment arising out of employment notice dated so and so. However, in view of the specific ouster clause number 11 in the employment notice dated so and so, the question posed for consideration is whether the OA before the CAT Ahmedabad bench is required to be entertained or not, and or the petitioner is required to be relegated to approach the appropriate forum, namely CAT Tribunal Mumbai bench and High Court Mumbai, in view of the specific ouster clause of 11 of employment notice dated so and so, restricting territorial jurisdiction of the CAT Mumbai bench and High Court Mumbai only. Judges will find that after this, the penultimate paragraphs of 4.06 and 4.07 of the Zala judgment have not been taken into note by the Honorable Tribunal. Yes, and they continue. Therefore, as both Central Administrative Tribunal Ahmedabad bench and Mumbai bench are having jurisdiction, and by clause 11 of the employment notice dated so and so, with the consent of both parties, one of the jurisdiction was ousted, which is not against public policy, since clause 11 jurisdiction confer upon Mumbai bench also having territorial jurisdiction as part cause of action has arisen there at Mumbai head office of the Western Railway. Learning Standing Counsel for the respondents further has preferred two judgments of the Honorable Apex Courts, ABC Laminate and Rajasthan State Electricity Board. As per the learned counsel for the applicant, the facts of the aforementioned two judgments of the Honorable Supreme Court as well as the judgment of the Honorable Gujarat High Court are totally different and distinguishable than the present case of the applicant as well as the petitioners before the CAT Jaipur bench and Allahabad bench. And as those facts were not considered by our coordinate benches, therefore let us consider whether these judgments would have any binding precedence effect on us or not. In the case of ABC Laminate, the fact is that the first appellant is a manufacturer and supplier of metallic yarn under the name and style something metallic yarn, having its registered office at Udyog Nagar, Mohammadnagar, Gujarat, within the jurisdiction of the Civil Court of Kaira. The second appellant is a sister concern of the first appellant doing business with it. The respondent is a registered partnership firm doing business in metallic yarn and other allied products at Salem. In this background, the parties had come to an agreement wherein clause 11 of the said agreement, it has been stipulated that any dispute arising out of this sale shall be subject to Kaira jurisdiction. In the said case, when disputes arose between the parties out of the said contract, then the respondent AP agencies filed a suit against the appellants in the Court of Subordinate Judge at Salem. However, the appellants took the plea that as per clause 11 of the contract, the jurisdiction with regard to all disputes arising out of the contract would be at the Civil Court at Kaira. The said issue, whether on an agreement which purports to ouster jurisdiction of the court absolutely is in contrary to public policy or not, was under consideration before the Honorable Apex Court, wherein it has been observed that. Thereafter, they observed the findings of the Honorable Apex Court. Your Lordships will kindly come to page 318, paragraph 25. Here, the learned tribunal has then thereafter considered Rajasthan State Electricity Board. The Honorable Apex Court in the case of Rajasthan State Electricity Board observed that the appellant board, which is having its base in operation at Jaipur, placed for an order for supply of 50 kiloliter of transformer oil with the respondent company, which is having its registered office and manufacturing unit at Calcutta. Both the parties entered to an agreement at Jaipur, and as per condition contained in clause 31 of the said contract of arbitration, it has been agreed by both the parties that in the case of any dispute, same shall be referred to the chairman RSCB Jaipur or any person appointed by him for the purpose. The said party had also entered into another purchase agreement wherein at clause 7 it has been incorporated that all disputes, differences, or questions, whether which may arise between the purchaser and the supplier upon or in relation with or in connection with the contract, shall be deemed to have arisen at Jaipur, Rajasthan, and no court other than the court at Jaipur shall have jurisdiction to entertain or try the same. Now, in this backdrop, the Honorable Apex Court was required to apprise whether the ouster clause of the agreement between the parties will also be applicable in ascertaining for making reference under section 21 of the Administrative Tribunals Act 1985. The Honorable Apex Court, while considering the case of ABC Laminate as well as Hakam Singh versus Gammon India, reported in so and so, it was observed at para 22 that there are a number of decisions of this court wherein it was held that where there may be Lordships. Twenty-nine page.
What happened to the Gujarat case? Whether that was upheld by the.
Lordships, it was never challenged. I have
Never
checked that it has never been challenged, Your Lordships. So it holds the field.
And what is the Rajasthan judgment?
Lordships, Rajasthan judgment, unfortunately, we did not annex with this thing. I'm just producing copies of that.
Yes.
कौन सा ये नहीं Lordships are talking about the OA
Cat judgment.
CAT judgment. Lordships. जयपुर वाला हाँ और दूसरा एक और था ना इलाहाबाद हाँ वो भी दिखा दे वो दे दे तुम्हाला दिसलो आहे त्याच्या वेगळे त्याच्या आम्ही ऍडजस्टमेंट आर्ग्युमेंट सगळं जे काही करतो हे तो कुठून डिस्टिंग्विश करू सा त्यात दिसून হেতুৱে তো তুমি ক'লা যে these are different on facts and all that কিন্তু জালা নহয় আৰু যে দুটা ফ্যাক্টৰ যে দেখুৱাইছিল paragraph 5 of the judgment of the Jaipur bench.
There was one, somewhere I found in it, one judgment of our High Court on this Siliguri and somewhere here in this records.
No, you're not.
Mr. Das, Siliguri, NF Railway, is it in this records?
Yes, my lord, I have given.
He might have given, yes.
My lord, I have given with the written submission, my lord, but there is not annex here, but I have given a number, my lord.
Written submission.
No, no, it's here.
So I believe he had quoted it in his this thing, in his written arguments.
Yes, in my written submission, my lord, before the learned tribunal, WPC 1937/2021, I enclosed the copy along with the written submission, but it has not been enclosed here. Oh, my lord, I'm sorry, my lord, it's there. It's there, my lord. Page 259. It's a railway matter, my lord.
Which case, which repetitive, which?
Same
The same repetition for item number 4. But this is on facts, this is different.
So mainly you are relying on that Gujarat judgment.
Lordships, and also naturally ABC Laminate, Your Lordships. Although that was a case of a contract, no doubt, But however, that in fact, recently in 2020, there's a judgment of the Honorable Apex Court. Of course, that is a little different in the sense that the Honorable Chief Justice, as he then was, has considered the jurisdiction of the High Court under Article 226. But ABC Laminate has been considered and has been upheld in that case, and they have taken note of the fact that the ouster clause would perhaps actually remain. I can place that judgment 2021.
Where is that ABC judgment?
Lordships, it is, I have given a list of books. It is not annexed, your Lordships. 1989 to SEC, page 163. Another important aspect was that, Lordship, the procedural part of it. The matter was taken up as an unlisted matter on the day that he tried to move it before the Honorable Tribunal. The procedure part.
That is,
No, Lordships,
that is
after
altogether,
having,
if we hold that, it's a, cat has no jurisdiction, then everything. Will be
everything will
settled.
go
And
naturally.
if we
But it is my duty to
decide
point
that
out.
if the cat has jurisdiction, then what
It is my duty to point out that there were some procedural lapses which were also, which
we'll
we,
ignore that.
Lordships,
The broader issue,
Lordships.
what would be the effect of that outer clause? This is what the issue which we have to take it to decide. That's all.
Yes, your Lordship. Your Lordships will kindly take up page number 160, 170 of ABC Laminate. Paragraph 12, your Lordships. If I may read, your Lordships.
Yeah.
A cause of action means every fact which, if traversed, it would be necessary for the plaintiff to prove in order to support his right to a judgment of the court. In other words, it is a bundle of facts which, taken with the law applicable to them, gives the plaintiff a right to relief against the defendant. It must include some act done by the defendant, since it is in the absence of such an act, no cause of action can possibly accrue. It is not limited to the actual infringement of the right sued on, but includes all the material facts on which it is founded. It does not compromise evidence necessary to prove such facts, but every fact necessary for the plaintiff to prove to enable him to obtain a decree. Everything which is not proved would give the defendant the right to immediate judgment must be a part of the cause of action. But it has no relation whatever to the defense which may be set up by the defendant, nor does it depend upon the character of the relief prayed for by the plaintiff. Now, thereafter, they consider section 20C of the CPC. You also may kindly skip this part and read paragraph 18 at page 173.
Yes.
In Hakam Singh versus Messrs. Gammon India Limited, the appellant agreed to do certain construction work for the respondent, who had its principal place of business at Bombay on the terms and conditions of a written tender. Clause 12 of the tender provided for arbitration in case of dispute, and clause 13 provided that notwithstanding the place where the work under the contract was to be executed, the contract shall be deemed to have been entered into by the parties at Bombay, and the court in Bombay alone shall have jurisdiction to adjudicate upon. On dispute arising between the parties, the appellant submitted a petition to the court at Varanasi for an order under Section 20 of the Arbitration Act 1940 that the agreement be filed and an order of reference be made to an arbitrator or arbitrators appointed by the court. The respondent contended that in view of the clause 13 of the arbitration agreement, only the courts at Bombay had jurisdiction. The trial court also held that the entire cause of action had arisen at Varanasi and the parties could not by agreement confer jurisdiction on the courts at Bombay, which they did not otherwise possess. The High Court in revision held that the courts at Bombay had jurisdiction under the general law and hence could entertain the petition, and that in view of clause 13 of the arbitration agreement, the petition could not be entertained at Varanasi and directed the petition to be returned for presentation to the proper court. On appeal therefrom, one of the questions that fell for consideration of this court was whether the courts at Bombay alone had jurisdiction over the dispute. It was held that the Code of Civil Procedure in its entirety applied to proceedings under the Arbitration Act by virtue of Section 41 of that Act. The jurisdiction of the court under the Arbitration Act to entertain a proceeding for filing an award was accordingly governed by the provisions of the Code of Civil Procedure. By the terms of Section 20A of the Code of Civil Procedure, read with explanation 2 thereto, the respondent company, which had its principal place of business at Bombay, was liable to be sued at Bombay. It was held that it was not open to the parties to agreement to confer by their agreement jurisdiction on a court which did not possess it under the code. But where two courts or more have under the Code of Civil Procedure, jurisdiction to try the suit or proceeding, an agreement between the parties that the dispute between them shall be tried in one of such courts was not contrary to public policy, and such an agreement did not contravene Section 28 of the Contract Act. Though this case arose out of an arbitration agreement, there is no reason why the same rule should not apply to other agreements insofar as jurisdiction is concerned. Without referring to this decision, a division bench of Madras High Court and so observed that competency of a court to try an action goes to the root of the matter, and when such competency is not found, it has no jurisdiction at all to try the case. But objection based on jurisdiction is a matter which parties could waive, and it is in this sense, if such jurisdiction is exercised by courts, it does not go to the core of it so as to make the resultant judgment a nullity. Thus, it is now a settled principle that where there may be two or more competent courts which can entertain a suit consequent upon a part of the cause of action having arisen therewith, if the parties to the contract agreed to vest jurisdiction in one such court to try the dispute which might arise as between themselves, the agreement would be valid. If such a contract is clear, unambiguous, and explicit, and not vague, it is not held by Section 28 and 23 of the Contract Act. This cannot be understood as parties contracting against the statute. And this particular paragraph and this particular finding of the Honorable Apex Court has been thereafter upheld in 2020 by Justice D.Y. Chandrachud in Maharashtra Chess Association versus Union of India Lordships. इसको list of book में दिया था 2020 13 SSC 13 SSC page 285. Paragraph 21 of ABC Laminate again reiterates what has been said in paragraph 18, Your Lordship.
It's a advertisement.
What is the advertisement?
Sorry, it's here.
The advertisement, Your Lordships, will find at page 46. It starts at page 46. The relevant clause, Your Lordships will find it.
Just.
Yes, Your
Examination.
What?
No, many cases. Page. Clause 4. Mode of selection. Mode of selection is first by a computer. From there, the computer takes this. Assam is also there. Thereafter, Then we realized that she had a dedicated method of it. It was not really beautiful university. It was really important. It was also very important how we think. She was very important. It's very deeply is very good last one. Which means we get to everyone check the paper. Basically, fix it. Push the goal of the yeah. In that view, what is the view of that? In fact, the ruling is difficult to get. It was in looking of
Well, now come to paragraph number 18.
Lordships.
Now next page 174,
Lordships.
when the minutes, thus it is now a settled principle
Yes, your Lordships.
where there may be of two or more competent courts which can entertain a suit consequent upon a part of cause of action
Lordship.
having arisen therein. If the parties to the contract agree to vest jurisdiction in one such court to try the dispute which
Correct.
might arise between themselves, the agreement would be valid.
Correct.
Okay,
Lordships.
now here in your case, whether this applicant was having jurisdiction or having this can file a OA or whatever the proceedings in Delhi.
Lordships, the reason why the ouster clause is brought in is
Just-
my respect for submission. I'm
Because the
answering.
court has come where two courts are having jurisdiction and if parties have entered into an agreement, out
Lordships.
of those two courts, one would be the place of whatever the litigation or what.
I started my
Then-
argument by saying that there's no dispute that otherwise the tribunal at Guwahati would have had jurisdiction.
Delhi,
Otherwise,
is there any remedy available
Lordships,
to
Delhi
that
is
applicant to approach the courts of Delhi or CAT Delhi?
Cat Delhi, your Lordships. Yes.
Where is that?
I do not understand the question, Lordships. Because
But
at
again-
page,
again,
page,
You read this,
Lordships,
thus it is now settled.
Lordships.
Thus it is now settled principle that where there are two or more competent courts which can entertain a suit consequent upon a part of person having arisen therewith.
Hmm.
If the parties to the contract agree to vest jurisdiction in one such court and try the dispute which might arise between that agreement would be valid.
Correct.
So if the parties have two competent courts of jurisdiction,
Correct.
one at Guwahati or suppose another is at Calcutta.
Yes, yes.
And if the parties come to an agreement that whatever the dispute would arose, the subject of jurisdiction will
Would
be
be
Guwahati.
Guwahati, Lordships. Assuming.
Now you can't say a third place which has no connection with their, no jurisdiction is there.
No, Lordships,
Now,
Delhi,
now
Delhi
suppose,
because-
you entered into an agreement between the parties in case of any dispute,
Lordships.
they jurisdiction of the
Lordships.
Bombay. has
Delhi,
jurisdiction
because
to
the
try this.
entire process was held from Delhi, Your Lordships, from the NCR region.
Where is that?
that is
That's why only, that's why only we asked you the advertisement.
Lordship-
NCR Delhi needs
Lordship,
to
but-
Noida.
Lordships, it is from, our headquarters is in Noida, yes, no doubt. But the entire jurisdiction for the purpose of convenience of all this, considering the fact that it was a pan-India drive, Your Lordships, just to maintain to ensure that numerous litigations are not held all over the country, one place is fixed by the authorities. In any case, Your Lordships, my learned friend has not deemed it fit to challenge this particular clause, either before this honorable court or before the honorable tribunal. He has not challenged this clause. He has not made any challenge to the advertisement itself.
Contract.
Yes. Oh, but it could also be in.
problem is that otherwise also this applicant has no right to approach any court of Delhi in that case. Yes, they agreed it, but
Lordships, the fact remains that
cause of action was not at all there in Delhi,
Lordship,
or
considering
even
the
part
fact
of
that it is a
part cause of action.
Lordship, considering the fact that it was a part of a pan-India drive, New Delhi being the capital, that is what the normally in all advertisements of Navodaya Vidyalaya Samiti, that is the clause which is inserted just to ensure that there is a uniformity of proceedings, Your Lordship. That is the only reason behind this clause. There are our argument before the tribunal was twofold. One was the
That argument
jurisdiction.
certainly would have been considered if they were they would have challenged that validity of that. In that case,
That
argument is,
Lordships, he did not deem it fit to even challenge the validity of the clause.
but as per this ABL judgment, where two competent courts have jurisdiction.
Lordships will also read paragraph
Now-
21 for a moment in ABC Laminar,
Para
21, Your Lordships.
21 read.
21. From the foregoing decisions, page 175. From the foregoing decisions, it can be reasonably deduced that where such an ouster clause occurs, it is pertinent to see whether there is ouster of jurisdiction of other courts. When the clause is clear, unambiguous, and specific accepted notions of contract would bind the parties, and unless the absence of ad idem can be shown, the other courts should avoid exercise jurisdiction. As regards construction of ouster clause, when words like alone, only, exclusive, and the like have been used, there may be no difficulty. Even without such words in appropriate cases, the maxim expressio unius est exclusio alterius, expression of one is the exclusion of another, may be applied. What is an appropriate case shall depend on the facts of the case. In such a case, mention of one thing may imply exclusion of another. When certain jurisdiction is specified in a contract and intention to exclude all others from its operation may in such cases be inferred. It has therefore to be properly construed. Lordships, in this backdrop, in the instant case, the applicant respondent was very much well aware of the fact that in case of any dispute, the jurisdiction would lie before Delhi. Having read the advertisement, having been aware of the entire provisions of the advertisement, she deemed it fit to participate in it. And she also deemed it fit to participate in the interview when she was called for. And thereafter, having approached the tribunal by not only not challenging that particular clause, but also not annexing it, not even bringing it on record, Your Lordships, not before this honorable court, not before the honorable tribunal. The conduct of the respondent was such that it
Ultimately, now
The point-
your objection, the tribunal has dealt with it, and rightly or wrongly, whatever it has come to
Correct.
the conclusion.
So after assuming
Now
there
this matter, whether she has disclosed or not, that is altogether irrelevant for all purposes.
Madanlal दिखाओ तो ONGC.
Is the latest Supreme Court judgment which you are.
2020 Lordships. A little different on factual Lordships, but that particular paragraph has been reiterated. 2020, 13 SSC, page, it starts at 285 Lordships. Your Lordship will kindly read paragraph 9. This was a case of alternate remedy, Your Lordships. Paragraph 9 is may I read the Lordships? Paragraph 9.
Yes.
It is a well-settled principle of contract law that parties cannot by contract exclude the jurisdiction of all courts. Such a contract would constitute an agreement in restraint of legal proceedings and contravene Section 28 of the Contract Act 1872. However, where parties to a contract confer jurisdiction on one amongst multiple courts having proper jurisdiction to the exclusion of all other courts, the parties cannot be said to have ousted the jurisdiction of all courts. Such a contract is valid and will bind the parties to a civil action. This is as per ABC Laminar, Your Lordships. The rest of the discussions in this case were with regard to alternate remedy, Your Lordships.
Yes, because you want people to come to the- Okay, okay. Let me put it on for- okay. Even-
Lordships, there's one more case which I would like to place before your lordships. 1994 4 SSC, ONGC versus Utpal Kumar Basu, page 711. There also, your lordship, the same principle has been reiterated that even if the advertisement, here was a case where Calcutta was the headquarters, the advertisement was to be opened at New Delhi and the work was to be executed at Gujarat. There, the court held that the advertisement itself mentioned that the tenders should be submitted to EIL at New Delhi. And that arose, that those would be scrutinized at New Delhi and that a final decision whether or not to award the contract to the tenderer would be taken at New Delhi. Of course, this, I'm reading from paragraph 8, your lordships, at page 719,
Yes.
somewhere in the middle of the paragraph, your lordships. The advertisement itself, paragraph 8,
Citation.
page, lordships, 1994 4 SCC, page 711, ONGC versus Utpal Kumar Basu and others. Paragraph 8, your lordships. Nine. So where does the person go? Huh? Lordships, in fact, to answer your lordship's query about Noida, I have just checked up on the website. There's no bench of a cat available at Noida, and so that's why perhaps the jurisdiction might have been confirmed. I'm not absolutely sure. Paragraph 8. Lordships, in this judgment, whereas paragraph 6 talks about the cause of action.
No, what is
Paragraph-
troubling us,
Lordship,
that as per this ABL judgment and even this Maharashtra Chess Association judgment, the court has made emphasis on that, where two courts are having jurisdiction
lordships,
and one is excluded,
lordships.
then the parties are bound. But where
Okay.
two courts, the Delhi court has no jurisdiction.
No, that is what I was just trying to point out to your lordship, that perhaps there is no bench of the tribunal at Noida. I've just checked it up on the website and there doesn't seem to be a bench in this thing. And perhaps that is the reason why New Delhi has been, the principal bench has been made for this thing.
They
For,
could have referred the bench is not there, then they could have referred Lucknow or whatever the cat.
lordships.
That could be the Allahabad or
Lordships,
whatever it may be. where
Be
the
that as it may,
cat is
perhaps
having-
it's possible that we have made a mistake in issuing that particular clause. The fact remains that that clause was never challenged by the respondent applicant. She has participated in the entire process, being aware of the provisions of the entire advertisement.
Any law in your support of this argument?
Lordship, yes, several your lordships. I do not need to place those judgments where when
That is
when a
altogether
candidate,
different in
lordships, 1995, Madan
constitution
Lal,
of the interview board and all,
lordship,
that case certainly,
lordship, 1995, 3
judgments.
SSC, Madan Lal case, your lordships. And Dhananjay Malik, 2008.
specifically where the Delhi court or any other court which the parties have agreed or there is a stipulation of this effect in the contract has no jurisdiction, then also it is bound for any party to approach that court only. That is to be seen.
Lordship, that was in fact what was held by the Honorable Gujarat High Court in the Zala judgment, that they have taken note of the fact that there's a reason behind the ouster clause. Lordship, we are not, there is, I once again reiterate that there is no dispute on the fact that under Rule 6(2) of the CAT procedure rules, it is the tribunal who has jurisdiction otherwise. But having known the existence of an ouster clause, whether it was correct on the part of the applicant to have approached the tribunal at Guwahati bench, and also without disclosing that particular aspect. Okay, otherwise.
It was actually going on in part.
कुछ दिखाओ धनंजय मल्लिक। ये क्यों रखा है? Neat. Well, this is. I'm not going to be a book. What I want. Oh no. 2008 4 is 9, but 2004 is. The 21 12 50.
Yeah.
Lordships, so far as your Lordship's query of the selection process is concerned, I'm relying on a judgment 2021 12 SEC, page 80. Chief Manager, Punjab National Bank versus Anit Kumar Das, your Lordships.
2021.
12 SEC, page 80. Here was a case where an appointment, after having the entire selection process having been complete, appointment was denied on the ground that they had suppressed material facts. Paragraph 16 would be the effective paragraph, your Lordships, at page 87.
Yes.
If I may read paragraph 16, your Lordships.
Yeah.
It is required to be noted that the eligibility criteria, educational qualification mentioned in the advertisement inviting the applications was as per circular letter number so-and-so, the relevant portion of which is reproduced herein above. As stated in the counter to the writ petition, a conscious decision was taken by the bank providing eligibility criteria or educational qualification that a graduate candidate shall not be eligible for the post of peon or subordinate staff. The said decision was taken consciously looking into the nature of the post. At this stage, it is required to be noted that the original writ petitioner never challenged the eligibility criteria or educational qualification mentioned in the advertisement. He participated in the recruitment process on the basis of the advertisement without challenging the eligibility criteria or the educational qualification mentioned in the advertisement. Therefore, once having participated in the recruitment process as per the advertisement, thereafter, it is not open for him to contend that acquisition of higher qualification cannot be a disqualification, and that too, when he never challenged the eligibility criteria or the educational qualification mentioned in the advertisement. There are several other cases wherein it has been laid down that the advertisement having been in the knowledge of the candidates. Qualifications. मिला क्या 2008 वाला धनंजय मिले क्या है ये अब मेरिट्स के ऊपर
Yes.
Lordship, that is about all. I do not want to trouble your Lordship with anything else. My case was very simple. Two grounds, two preliminary objections which we had taken was one on the point of jurisdiction and one on the other on the conduct of the party, that she did not approach the tribunal with clean hands. On both counts, the honorable tribunal had
Rejected your
presented,
objection.
rejected this thing, and had, in fact, Lordship, I should just point out that in the meanwhile, the honorable tribunal had also asked us.
Petitions, why these two petitions?
In the first one, your Lordships, which is against the MA, which was filed by him for removing the defect in the entire process, that the honorable tribunal assumed jurisdiction upon it and thereafter passed the judgment in the first writ petition. By the way of the second writ petition, the honorable tribunal took up the matter for admission, took it up on merits, and then asked us to keep one post vacant in the entire process, which we have done, your Lordships. One post remains vacant as per this thing. What has been stayed by the Honorable High Court is the entire proceeding before the CAT. That has been adjourned, sine die, your Lordships. I am deeply obliged, subject to what my learned friend says.
Lord, my facts are very simple. I am a resident of the state of Assam. They have issued an advertisement. I participated in that advertisement. Now, the computer-based test, the first exam, CBT.
You participated in that advertisement very well knowing
Yes.
that in case of any dispute, in case of recruitment or anything else, you have to approach the Delhi court. You have not challenged that condition.
Lord, I'll just come to that.
With
Lord.
open eyes, you applied for that and you have not challenged the
Lord,
condition of the advertisement.
In my humble submission, my lord, that clause 23, as has been held by the learned tribunal, is void ab initio, because no parties unilaterally cannot decide the jurisdiction, because the question of jurisdiction is based on public policy, my lord. It's a public law remedy. My lord, what the Honorable Apex Court also held in this regard, my lord.
Why you have not disclosed this fact that the Delhi court, as per the advertisement, only the Delhi court has the jurisdiction, but whatever the condition mentioned in the advertisement is void ab initio, therefore I am approaching this tribunal.
My lord, with all this, with all due respect, my
You
lord,
even suppress this fact.
no, my lord, there was no suppression. That was,
As what
that
they are saying.
that was properly explained before the learned tribunal. My lord, what happened?
At what point of time when they raise objection?
No, my lord. My lord,
Prior to that. Along with your OA, you have
my lord, what happened in this matter? I'm just explaining, my lord. What happened in this matter? Initially, he approached this honorable court. She approached. My lord, I'm just.
Court has relegated. Go before.
No, not only that, my lord. In that writ petition also, that last page was not there. In the writ petition filed before this honor, it was.
Advertisement last page.
Yes, my lord.
Why?
It was. My lord,
Why?
it was an inadvertent mistake while downloading the page.
Once or twice.
My lord, once.
No, twice.
In the court,
No,
you
no,
have
no,
not
that is-
disclosed it. In the tribunal, you have not
No,
disclosed
no.
it.
That is what I am trying to explain, my lord. One set of counsel was there before the High Court who filed the first writ petition in the High Court, my lord. That last page was not there before the High Court. My lord, that writ petition, when this honorable court relegated to the tribunal, my lord, that writ petition was, copy of the writ petition was given to the second counsel to prepare the OA. My lord, my lord, had it been a case that I would have given in the writ petition and omitted in the OA, my lord, then there could have been a
But
doubt.
there is a case that in neither before the High Court nor before the tribunal, you have disclosed this fact. This is also a fact.
My lord, I am not at all benefited from that. No, my lord, lordship will kindly
If you
appreciate
benefited, how can?
that. My lord, the applicant has filed an MA before the learned tribunal seeking
maybe the
apology.
tribunal- Then maybe the tribunal could have returned you the brief that no, we have no jurisdiction since this clause is there.
No, the entire thing, this hearing was happened before tribunal entertaining for admission or issuing notice even.
When they raised this objection, then this issue cropped up.
Yes,
to that, there was no
prior to that, on the first day itself, my lord, this was raised by the respondents. And my lord, I was there before the tribunal, my lord.
I sought apology before the tribunal that was an inadvertent mistake. Applicant has filed an MA praying for inclusion of that page in the records of the way. Thereafter, entire thing was heard and finally decided by the learned tribunal to issue notice and admit, my lord.
Okay, now come to the merits.
Yes, so far as the, my lord, jurisdiction portion is concerned, they have issued an advertisement. The most crucial aspect is the vacancies which were advertised were for northeastern region. I submitted my candidature. I am a resident of my lord, state of Assam. I appeared in CBT, computer-based test in Shillong.
And then
Thereafter, they have called.
you participated in the interview where?
Thereafter, I was called for interview to Chandigarh, wherein they raised a dispute with regard to my qualification that I am not, because I am a my lord, chemical science. I am a MSc in chemical science. They have raised dispute with regard to the terminology. I submitted the transcript of my degree before them also.
That is the matter which is pending before the tribunal.
Yes,
Not all
I'm
facts. We
just
are not
placing the.
touching that.
Yes, I'm just placing the facts, my lord.
Yeah, these are the
So
facts are clear.
therefore, rule 6(2) of the CAT procedure rule, if my lord kindly takes up, it says an application shall ordinarily be filed by an applicant with the registrar of the bench within whose jurisdiction, number one, the applicant is posted for the time being, or the cause of action wholly or in part has arisen. Provided that with the leave of the chairman, the application may be filed with the registrar of the principal bench and subject to the order under section 25, such application shall be heard and disposed of by the bench which has jurisdiction over the matter. So it says that cause of action wholly or in part. My lord, in my respectful submission, not a single cause of action had arisen in Delhi. The entire cause of action.
So all the selected candidates or whatever it may be,
Yes.
they were called for interview in Chandigarh or different parts of the country.
My lord, that I'll just check, my lord. Chandigarh, Chandigarh, partition
Yes, yes. Page 82. पूरा लिस्ट है क्या इसमें?
I'll just
बुलाया
check.
था। हाँ, पूरा लिस्ट है ना हमारे पास। नहीं, यहाँ पे 40% आगे रखो। ओ नहीं, कौन सा? Page 79, 80 आता है ना? 79 of यहाँ से बूटे हमारे ब्लड के मार्केट में और 82 is your call letter. सबों के चंडीगढ़ में।
So you have called the all those persons for interview in one place, Chandigarh, or
Lordship,
different?
to my knowledge, there were 4 zones identified and different people were relegated to different areas. In fact, the written test was held at Shillong at Nehu, where she participated. Then thereafter, Chandigarh was only one of the places where, because it was a pan-India day, there were several candidates. Your Lordship will find that list at page 79. We have next, Chandigarh was for 118 candidates. She was one of them.
Delhi was there?
Lordships, it does not reflect. I'm sure it must have been, I perhaps might have been there. I do not know, Lordships. I will have to check up on that. CBT का क्या? ये कहाँ पे? Page 56 is relevant if your Lordships may just see for a moment where it stated that the CBT will be held at Delhi. नहीं है 56 पे नहीं. 50? क्या हो गया तुम्हारा मेरा मैच क्यों नहीं कर रहा? 57 पे चल रहा. नहीं यार तुम क्या बोलते हो? Lordships will find that at page 57, the mode of selection in the advertisement itself, it was stated that the candidate was required to give 3 different options.
Page,
Page 57 of my paper book, your Lordships, 57, I can check for an item.
118.
Page 57.
Mode of selection.
Yes, your Lordships. B point, your Lordships. The CBT for the recruitment of the notified posts except principal. So she had applied for PGT, your Lordships. Is likely to be held at the following cities. Candidates are required to give 3 different options in order of their preference. The centers of examination CBT will be decided by NVS through the preferences options submitted by the candidates to the extent of availability of computer nodes at such center. This was,
My options, your Lordship will find page 207.
No, this is for the, this thing.
CBT.
This was for the computer-based test, your Lordships. This is not for the interview. Interview, huh? It's for the CBT. For the CBT, yes, she had selected this thing and therefore she was given Nehu Shillong as per her this thing. As per her first preference. Meghalaya Shillong was her first preference and therefore she was given Nehu. क्या हो गया? She's calling me.
Yes.
My lord, in my written submission, my lord, I relied on two judgments, my lord. My lord will kindly have page 248. Relevant paragraphs, my lord, I have quoted herein.
Yes.
May read just para Q, my lord.
248.
248 of the paper book, my lord. It's my written submission.
247, sir.
I'm so sorry, my lord.
Your lordship
47.
says, move to 248 है वैसे. So there's some.
My lord, the para is Q, my lord.
क्या हो गया? You can pick this.
May I read, my lord?
Yeah.
The applicant is relying on the law laid down by the Honorable Apex Court in the case of Naval Kishore Sharma versus Union of India, reported in 2014 9 SCC 329. In support of our contention that the CAT Guwahati bench has got the territorial jurisdiction to entertain the original application, taking into consideration the fact that the whole cause of action arose within the territories of CAT Guwahati bench, the relevant paragraph is para 17, which is quoted below for ready reference. We have perused the facts pleaded in the writ petition and the documents relied upon by the appellant. Indisputably, the appellant reported sickness on account of various ailments, including difficulty in breathing. He was referred to hospital. Consequently, he was signed off for further medical treatment. Finally, the respondent permanently declared the appellant unfit for sea service due to dilated cardiomyopathy. As a result, the shipping department of the government of India issued an order dated so and so cancelling the registration of the appellant as seaman. A copy of letter was sent to the appellant at his native place in Bihar, where he was staying after he was found medically unfit. It further appears that the appellant sent a representation from his home in the state of Bihar to the respondent claiming disability compensation. The said representation was replied by the respondents, which was addressed to him on his home address in Gaya, Bihar, rejecting his claim for disability compensation. It is further evident that when the appellant was signed off and declared medically unfit, he returned back to his home in the districts of Gaya, Bihar, and thereafter he made all claims and filed representation from his home address at Gaya. And those letters and representations were entertained by the respondents and replied, and decision of those representations were communicated to him on his home address in Bihar. Admittedly, the appellant was suffering from serious heart muscle disease. I'm sorry, Milu.
Yes.
The next judgment that I relied on before the learned tribunal,
This 2020-10 SEC.
2020-10 SSC, 766, paragraph 28, 29, Para 34 in page 251. We are also of the view that the appellant is entitled for an interim order in the writ petition for her sustenance. The appellant's husband who had filed the writ petition had died during the pendency of the writ petition. After his death, the appellant, the widow, was substituted. 6 years had passed after filing of the writ petition.
Yeah, this next judgment 1994.
Yes, this is important, Milord.
Yeah.
This is important, Milord.
Read.
Milord, para 5, Milord, if I may read.
Yeah.
Clause 1 of Article 226 begins with a non-obstante clause, notwithstanding anything in Article 32, and provides that every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue any person or authority, including in appropriate cases any government within those territories, directions, orders, or writs for the enforcement of any of rights conferred by Part 3 or for any other purpose. Under Clause 2 of the Article 226, High Court may exercise its power conferred by Clause 1 if cause of action wholly or in part had arisen within the territories over which it exercises jurisdiction, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. On a plain reading of the aforesaid two clauses of Article 226 of the Constitution, it becomes clear.
That's right. You have referred up to para number 6.
Yes, Milord.
Now come to para number 8 of this judgment.
It is not annexed that part.
Milord.
Given the para number 8.
Yes, Milord. From the facts pleaded in the writ petition, it is clear that NICCO invoked the jurisdiction of the Calcutta High Court on the plea that a part of the cause of action had arisen within the territorial jurisdiction. According to NICCO, it becomes aware of the contract proposed to be given by ONGC on reading the advertisement which appeared in the Times of India at Calcutta. In response thereto, it submitted its bid or tender from its Calcutta office and revised the rates subsequently. When it learned that it was considered ineligible, it sent representations including fax messages to EIL ONGC at New Delhi demanding justice. As stated earlier, the steering committee finally rejected the offer of NICCO and awarded the contract to SIMCO at New Delhi. Therefore, broadly speaking, NICCO claims that a part of the cause of action arose within the jurisdiction of the Calcutta High Court because it becomes aware of the advertisement in Calcutta. It submitted its bid or tender from Calcutta and made representations demanding justice from Calcutta on learning about the rejection of its offer. The advertisement itself mentioned that the tender should be submitted to EIL at New Delhi, and that those would be scrutinized at New Delhi, and the final decision where or not to award the contract to the tender would be taken at New Delhi. Of course, the execution of the contract work was to be carried at Hazira in Gujarat. Therefore, merely because it reads the advertisement at Calcutta and submitted the offer from Calcutta and made representations from Calcutta would not, in our opinion, constitute facts forming an integral part of the cause of action. So also, mere fact that it sent fax messages from Calcutta and received a reply thereto at Calcutta would not constitute an integral part of the cause of action. Besides fax messages, fax message of 15/193 cannot be construed as conveying rejection of the offer as the fact occurred on 27/193. We are therefore of the opinion that even if the averments made in the writ petition are taken as true, it cannot be said that the part of the cause of action arose within the jurisdiction of the Calcutta High Court. Milord, this is
the answer.
Yes, Milord. This is, Milord, with regard to that, the company was in Calcutta. He submitted representation.
Your case is that you filed an application from Guwahati, you appeared, you read this advertisement in Guwahati and you appeared in the examination in Shillong, and therefore it's a cause of action for that. In such cases where the advertisement is pan-India, then we have to take into consideration that not a cause of individual cause of action, it's a pan-India selection. Wherein if they have after considering all these things, if they has clarified that the jurisdiction of the Delhi court will have the Delhi court has the only jurisdiction, then there is some.
Milord, if I may explain, Milord, had it been a pan-India recruitment for filling,
Otherwise, you know, here they have mentioned around more than 50 centers or around 100 centers, whatever it may.
Milord,
Then it would
yes.
be very difficult for them in every part of this, if the people applies for that, then it would be very
Milord,
difficult.
what my submission is that, Milord, one important aspect, Milord, that has not come before your lordships, that the vacancies are where. Lordship will kindly come to the advertisement for a moment, Milord. Lordship will kindly come to the advertisement. This was a special recruitment drive. This was not a recruitment drive to fill up posts all over the country, Milord. This was a special recruitment drive only for northeastern region, Milord. The vacancies are for page 204, Milord.
Yes.
Oh, not you.
Page 204. So by virtue of this, Milord, the entire cause of action comes down to northeastern region. General instructions to the candidates.
Categorize this cause of action, then
Sorry, Milord.
why not in this Noida, Uttar Pradesh? Since the advertisement issued from there,
No, if your lordship,
everything was managed from there and supervised from there.
if page 204,
Yes,
6 general instructions to candidate,
yes,
para 2.
yeah.
Selected candidates will be posted only in JNV under Shillong region, located in northeastern states. In Arunachal, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim, Tripura. So the posts which were Milord advertised, those belong to northeastern states. That a candidate is selected, he'll come and join here.
But this process was initiated where?
Milord,
This process was initiated
Milord,
where?
in railway, say for example, Milord, Railway Recruitment Board initiates recruitment drive by issuing centralized advertisement, Milord. All of the railway zones are, Milord, vacancies are notified. In NF Railway, say for example, 5,000 vacancies are notified. Then if a person from Bihar has applied for the vacancies in NF Railway in Guwahati, and he has some grievance, then he'll have to file OA before CAT Guwahati bench.
Why
So
not
this-
in Bihar? Because he resides there and he applied
True,
from there.
true. That's why I'm saying so. Apart from the other contentions that I have made before your lordships, that I am a resident of Guwahati, Assam. I participated in from Shillong in CBS. The another important factor is where the vacancies belong to, where the posts are advertised, my lord. So in where the posts are advertised.
Yeah,
Milord, this vacancies has got significance in deciding the issue. Then, my lord, page 257, I relied another judgment of the Honorable Apex Court, Patel Roadways Limited, Bombay versus Prasad Trading Company, 1991, 4 SCC, page 257, my lord.
yes. Yeah,
The law laid down by the Honorable Apex Court in case of so-and-so is an absolute proposition of law on the point that choice of forum can be limited by incorporating exclusion clause under an agreement, but agreement cannot confer jurisdiction on a place it doesn't lie otherwise. It is precisely the situation in the instant case wherein the respondents are forcefully trying to confine territorial jurisdiction of the Honorable Tribunal at Delhi without a single cause of action there. The relevant paragraphs are quoted below. Para 13. As far as we can see, the interpretation which we have placed on this section does not create any practical or undue difficulties or disadvantages either to the plaintiff or the defendant corporation. It is true that normally under clauses A to C, the plaintiff has a choice of forum and cannot be compelled to go to the place of residence or business of the corporation or can file a suit at a place where the cause of action arises. If a corporation desires to be protected from being dragged into litigation at some place merely because a cause of action arises there, it can save itself from such a situation by an exclusion clause as has been done in the present case. The clear intendment of the explanation, however, is that where the corporation has a subordinate office in the place where the cause of action arises, it cannot be hard to say that it cannot be sued there because it does not carry on a business at that place. It would be a great hardship if, in spite of the corporation having a subordinate office at the place where the cause of action has arises, with which all probability the plaintiff has had dealings, such plaintiff is to be compelled to travel to the place where corporation has its principal place. That place should be convenient to the plaintiff, and since the corporation has an office at such place, it will be under no disadvantage. Thus, the explanation provides an alternative locus for the corporation's place of business, not an additional one. There may be only one extraordinary situation in which this interpretation may cause an apparent anomaly. This is where the plaintiff has also its place of business at the same place as the corporation, but the cause of action has arisen in some other place. The above interpretation would preclude him from filing a suit in that place of business common to both the parties and compel him to go to a court having jurisdiction over the place where the cause of action has arisen. But it is not really a hardship because such plaintiff must have had some nexus or connections with the place since some part of the cause of action has arisen there. If we can have dealings with the corporation at such place giving rise to the cause of action, there is no reason why we should find it disadvantageous or difficult to file the suit at such place. Equally, the corporation having a subordinate office at that place will suffer no disadvantage. My lord, here also in this case, the JNB has office here. They have got principal office in Delhi. My lord, as because they find that it will be convenient for us that the litigants will come to.
You mean to say that cause of action arisen, the petitioner has a cause of action in Guwahati, and therefore this CAT filed by him is maintainable, the OA filed by him before the CAT Guwahati is maintainable.
My lord, we are filing.
Your case was rejected where?
My lord, we are filing. I'm sorry.
Your candidature was rejected where?
My lord, she was not allowed to participate in the interview. She was sent back.
Chandigarh, na?
Chandigarh.
So a part of cause of action was also arising.
Maybe, my lord, but a part of cause of action has.
File a petition there in the Chandigarh.
No, lordship will kindly appreciate one thing. This is a public law remedy, my lord. So what they are trying to.
It's a advertisement. And the advertisement, pan India, the applications were invited. Then in that case, if we spread the jurisdiction of this advertisement in whole of India, it would be very, very difficult. Ultimately, whatever right or whatever the liabilities you have derived is from that advertisement only. In that advertisement, it is specifically made clear that in case of dispute regarding recruitment, the only the Delhi court has the jurisdiction, then
My lord, in my stand before the learned tribunal was that that condition incorporated by the respondents in the advertisement, it was an unconsignable contract. There was no agreement. All the Supreme Court judgment my learned friend placed before your lordships.
but the
Lordship
analogy can be drawn from that.
No, what I'm saying so.
Strictly speaking, there is no agreement between the parties, but the analogy from that can be drawn.
Milord, this is not a fact situation wherein we can compare this situation with a case law cited, wherein an advertisement issued, some conditions were there with regard to qualification and all. He participated in the selection process, and thereafter he cannot come and stop. Milord, here the fact situation is totally different, wherein they have incorporated one clause by which they have ousted the jurisdiction of a place where there is a tribunal and they are curtailing the jurisdiction of honorable tribunal. Can they do so by incorporating an advertisement, curtailing jury? In that event, Milord, tomorrow all the advertisements, say for example, Milord, all the advertisement will be issued saying that Guwahati High Court doesn't have a jurisdiction, Delhi High Court will have jurisdiction.
Should have challenged that condition.
Milord, my stand, Milord, what tribunal has held, Milord, it was an unconsignable contract, relying on Supreme Court decision in Brojanath Ganguly, Milord. I'm just trying, giving the relevant portion, what the tribunal has recorded, para 31.
We'll go through. That will go.
Para 31, learned tribunal has recorded that this was not agreed to, it was unconsignable. And what the Brojanath Ganguly has said, only 4 lines quoted, Milord. The state being a powerful employer and the candidates who had no power, and in that scenario, inclusion of such clause by which the applicant would be debarred from approaching the competent authority for proper jurisdiction is opposed to public policy and void ab initio, thus need not be challenged. And the relevant paragraphs of the law laid down by the Honorable Apex Court in Brojanath Ganguly, 1986 3 SCC 156. Milord, I have quoted in my written submission before the learned tribunal.
Right.
So my humble submission is that, Milord, by incorporating one clause for your convenience, you cannot take out the jurisdiction of a court. If had it been a case that, yes, I have entered into an agreement with another party that will confine our jurisdiction to this particular court or this particular tribunal, then it would have been a different. And that analogy, Milord, with all due respect, cannot be placed here because this was an unilateral condition inserted in the advertisement, Milord.
Fine.
And I'm not required or it's not mandated under the law to challenge that because of the law laid down by the Honorable Apex Court in Brojanath Ganguly, Milord.
Fine.
It was an inconsignable content.
Yes. That's all.
Yes. One important aspect, Milord.
Yeah.
The judgment relied on by my senior friend with regard to that Ahmedabad bench, Western Railway case, Milord. In that case, Milord, the advertisement was issued by the Western Railway for the post that surface in Western Railway. Person from Gujarat, Milord, applied. In that context, the tribunal as well as the Jala case, Milord, of Gujarat High Court had held that Milord, the Gujarat bench will not have, the Ahmedabad bench will not have jurisdiction. This vacancy has got tremendous significance. The Western Railway issued the advertisement saying that we need person. Milord, Gujarat boy applied. He was rejected. He then filed away in Gujarat. In that context, Milord, the High Court as well as tribunal held that Bombay bench will have the jurisdiction. It's not the case here, Milord. We are having the vacancies at Northeastern region. Milord.
Arguments heard. Order is there. Yes.
Deeply obliged, Milord. Much obliged.
I'm deeply obliged, Lordship.
Thank you so much.
Item number 5.
Lordship, responding to that last date on which I submitted that the project with which the respondent number one was associated, Lordship. Respondent has filed an affidavit denying that he is only a liaison officer. That is not correct, Lordship.
So
He is
what
the demanding officer to the project, Lordship. He is the one who conceptualized and he laid the objective. He asked for the money, demand for the, based on the project, progress of the project, Lordship. He is the demanding officer, not the liaising officer, Lordship.
Demanding officer, what do you mean by demanding officer?
Let me explain that. Let me explain this through an affidavit, Lordship. By tomorrow or day after tomorrow, Lordship, I'll let the matter come up on Friday.
The permission of the defense research to unfortunate list schedule for finance dedicated for fees 9 lakhs for party facing CR special reduction of the ground level during the
Lordship, he monitors the project.
Yes, sir. This is the for the procurement of
Lordship, for the research work, for which assigned to the Tezpur University, Lordship.
what is this?
Lordship will find he is the part of the
Just a
team.
minute, sir, please.
Sorry, Lord.
Nine lakh rupees projected. What is the importance of this? Only 9 lakh rupees project and nothing
No,
else.
that's the first,
And
that's
they
the
have
first.
simply ask for money, is provide us money, so.
No,
the-
Lordship, the next page, Lordship. Next page, Lordship.
Mr. Chekabert, no,
Lordship.
this your attitude itself, absolutely not acceptable.
Lordship,
How can you, if there is some important project, certainly we would understand.
Lordship.
But here in this case, now you are after this employee, no, will not release him. Whether you will be able to take work from him if he is not willing to do so. Ultimately, it's an institution where some persons having some zeal to do work, retain them. If a person is not at all interested in having and you are forcing
But
him,
he signed the willingness, Lordship. He signed the willingness to be
in the
associated with
willingness
that project.
in the year 2014.
No, this is not 2014, Lordship.
Had it been this person,
In 22, Lordship.
had it been this person in a private company, they would stick to him if he is not willing to even work. Some professionalism should be there in these organizations also. If a person is not interested, you are forcing him, no, do this, up to what extent he will do.
Lordship, by just relying on two decision, Lordship, may just look into it.
Decisions.
Where to post, Lordship? Right to post to a particular place, Lordship.
There is no dispute about that, but ultimately. And he asked money for whom?
For the project, Lordship.
For the project to be completed by whom?
That has to be executed by the Tezpur University,
So
Lordship.
he simply ask, provide some money so that Tezpur University may do some research work. Or
He is the one.
He is involved in that research work.
Lordship, he monitors based upon his report.
The people monitor it. Ultimately, it is the Tezpur University which is to do the research work. He is not the employee of the Tezpur University.
No, Lordship.
Then So you are passing an order or otherwise we are this making a statement, yes, after so much time we'll release him or what, or we'll pass a order. then
Lordship may
we'll-
pass the order, Lordship.
Then we'll pass a harsh order, you mind it. Make some observations about your whatever adamancy. Now mind it. You are willing to,
Lordship.
you are willing to have those observations?
The alternatives, Lordship.
The other alternate is pass and give some undertaking that will not retain this person beyond this period.
Lordship, for that I have to take instruction, Lordship.
Take
I
your
ca-
instructions.
I cannot of my own, Lord,
Yes, take your instructions. Tuesday.
Lordship.
Adamancy. And this person is, what qualification this person is having?
It must be in MSc. Lordship.
Biochemistry.
Biochemistry, yes, ma'am.
And you are asking him to do the mechanical.
Mechanical
works?
engineer, yes, ma'am.
क्या करेंगे आप?
All along he is harassed, my lord. Deeply obliged.
Tuesday. You come with a specific direction and or either ready for this observations. We are going to make fast observation.
For hearing, item 6.
May please your lordship. In compliance of your lordship's last order, I have filed the amended memo of party. It's marked as flag X1.
To whom you have made the party?
My lord, Tribal Affairs Plains Department, Assam, and
Union of India.
Union of India, my lord.
Who is appearing for those?
My lord, I am appearing for the state, my lord, Tribal Affairs Plains, Assam, my lord.
Union of India?
Union of India, my lord. Notices to go, my lord. These two parties, notice has to go, my lord. First time. No, naam dekho na. You notice the.
It's not reflected in the. Take care.
Yes, it's not.
Pursuant to the direction
Not
given
yet,
by
not
this
yet.
court on 3/8/2023, the petitioner has already implemented the petitioner pursuant to the direction given by this court on 3/8/2023, the Department of Tribal Affairs, Plain, and the Union of India. Only Department of. Plain of the state of Assam is implemented as party. Is also notice that Union of India through
Ministry of Tribal Affairs.
Department of Travel Plain is implemented as party. Respondent issue notice, Mr. So and so, appearing on behalf of the Department of Tribal Affairs, Plain, State of Assam, accept notice on behalf of accept notice. Let on behalf of the respondent number 6, newly added respondent number 6, Mr. Roy Chaudhary is appearing on behalf of the respondent number 5, Union of India. Copy of the writ petition be supplied to Mr. Chaudhary and Mr. So and so during the course of the day, today only. Supply the parties may file their response by the next date of hearing, list after 6 weeks.
Much
Well,
obliged, please.
Item 7.
Oh, sorry. Wait, on my count, my learned friend is in some problem. I had a criminal appeal listed before court number 5. So I said, I'll do that. And therefore, my learned friend did not open. So now he says,
No, we are simply, since it is the matter in respect of some, this flood occurred in 2018.
Yes.
And after that, now we are only concerned that whether at present, there is any system in vogue to control such type of floods in future or not. Since 2018, the incident took place and it has gone now on account of release of water by some authorities. Another state and both the authorities are blaming each other that they are responsible for that and they are responsible.
the district judge that's all was given an inquiry. The district judge has made an inquiry.
Now, is there any system in vogue to prevent such incidents? in future?
Natural, something which is natural cannot be prevented. This is one. Secondly, Golaghat district is flood prone area. Now, this NEPCO dam was established in 2000, 1999, 2000. And first time it happened because of incessant rain in 2018. And it has never happened. Thereafter, it has not happened. Before 18 also, it had not happened. And
the confidential report, neither here nor there. They are saying NIPO authorities are also responsible. However, the state government officials are also negligent.
We have, my lord, there is a report by the district judge wherein he says that we have informed them, given them in advance notice that we are going to release the water. And that is what we were supposed to do every year. There is a meeting of between the DDRM.
What happened has happened. Now, at present, is there any system in vogue to check these
My lord, there is, I will let this be taken up on 21st. I will place the whole thing.
Yeah,
21st.
maybe
Yes.
if there is some guidelines or something else.
My lord, there is one where every year there is a meeting between District Disasters Authority and NEPCO. And they meet and they decide what action they will take to prevent the flood. And actions are taken accordingly. Every year it is.
Okay, then you place it on record.
I'll place.
We are having this mechanism now.
Yes, it is there on record.
To meet all these eventualities.
I'll place it on 21st. Your lordship will take it out.
Concept, Mr. Sonto Senior Counsel appearing on behalf of the
I'm appearing. NEPCO.
NEPCO Limited place for a granted time to place on record the mechanism in vogue to prevent the situation of flood which arose in the year 2018 in Golaghat area. Golaghat region, in Golaghat region. List on 21st.
Item number 8.
Lordship, this matter may be fixed on next week, Lordship.
Adjourn.
Item number 10.
Your Lordship.
Yes, Lordship. Lordship, kindly pass over this matter for time being, my lord.
Why?
The counsel for the petition is coming, my lord. She has gone to hospital, my lord.
Compulsory retire in the year 1999. Or disability pension.
She is coming, my lord. That time.
Password for the time being, call her, but
My lord, my lord. Deeply, your lordship.
Item 11.
Lordship, I have informed the other side advocate.
which other side?
Lordship, for
You
the
have to inform your senior.
Lordship,
Please show us how this BSNL is aggrieved by this order. Have you gone through that order?
yes, Lordship, Lordship, the
What is against you in this order? What is against you? What direction was issued by the CAT against the BSNL? So you are aggrieved to file this petition. Please tell us how you are aggrieved by this order.
Lordship, in this matter, I have no proper instruction as senior is out of station.
Okay, will not pass any adverse order, but have you gone through the order? Or so do you feel there is any adverse order against the BSNL? Frankly, tell us, we are not going to pass any adverse order.
Is that order require you to take any action? Is there any direction to you to do something this way or the other? Then that is what my lord is asking.
Yes.
How are you then?
Yes. Where is your senior?
Lordship, he is out of India.
Out of building?
India's Lordship, and he has submitted his letter of absence also.
Yeah. But please ask him, I would say, please ask him how this BSNL is agreed and why you have filed this petition on behalf of BSNL here for water claim, claiming water claim.
Item 12.
As per instruction, my senior told that we are going to implement necessary parties.
You are going to impede them as party.
Lordship, necessary parties.
When?
Lordship, by maybe 24.
So by that time, you will impede those persons as party. How many persons are affected?
After 24.
Again. Yes.
Item 14.
Yes. May I please, your lordship? Lordship, this writ petition is directed against an order passed by the learned CAT, which your lordship will find at page 73. And the charge sheet has been quashed on the ground of delay. Here. Now, lordship, if I may take your lordship to page 90.
Yes.
Paragraph 6.
Yes.
Now, all the contentions raised as regards delay has been extracted by the learned tribunal from page 76 onwards. And the only contention that was raised by the learned CGC before the tribunal, lordship will see paragraph 6 below, it is quoted.
Yes, read.
The additional CGSC has submitted that though irregularities are pertaining to the year 2005 to 7, I'm sorry, 5 to 10. However, the irregularities were noticed only on 24/2011 when the circle office constituted a squad for carrying a review of the appointments in respect of 14 GDS BPMs, and a detailed report was submitted. He also submitted that the allegations made in the charge memo against the applicants are not mere procedural lapses, but are serious in nature. He submitted that the tribunal would be exceeding its jurisdiction in case the charge sheet is set aside. He brought to our attention the observations made by the Honorable Supreme Court in so and so. Lordship will see the quoted portion. In fact, Lordship, I'll pass on a copy of the judgment. Don't trust me. I'm not going to. Only because Lordship has taken note that the irregularities pertain to the period 2005 to 2011, which were noticed in 2005 to 2010, and which were noticed in 2011, and it has been sought to be quashed only because the charge sheet was issued 4 days before the person had retired from service. Now, what are the charges? Charges are grave, Lordship. Persons have been appointed who did not even apply, who applied later on. Those are the charges, Lordship. And in the particular case which I have given a copy to your Lordship, paragraph 10 thereof, of course, this it's a different journal, Lordship, the
Yes.
Masilamani. Court has, first I will refer to the quotation in page 90. The court tribunal should not generally set aside the departmental inquiry and quash the charges on the ground of delay in initiation of departmental proceedings. As such, the power is beyond the limits of judicial review. In the event the court tribunal exercises such power, it exceeds its power of judicial review at the very threshold. Therefore, a charge sheet or show cause notice issued in the course of disciplinary proceeding cannot ordinarily be applicable in relation to there being a delay in the conclusion of departmental proceedings. The facts and circumstances of the case in question have to be examined, taking into consideration the gravity, magnitude of the charges involved therein. The essence of the matter is that the court must take into consideration all relevant facts and to balance and weigh the same so as to determine if it is in fact in the interest of clean and honest administration that the judicial proceedings are allowed to be terminated only on the ground of delay in their conclusion. Now, Lordship will see the charges. What are the charges?
Yes.
If I may take your Lordship to page 22. Of the writ petition, Lordship. There are as many as 9 charges that the said D.N. Sharma, while functioning as SSPO Guwahati Division, is alleged to have selected a candidate, namely so-and-so, of village so-and-so, having 69.16 marks in higher secondary living certificate so-and-so. Guwahati memo number so-and-so dated 13/17/2010 for the post of GDPS BPN, the incumbent of which was under put off duty, allegedly rejecting the candidature of Sri Manmohan Das, son of Nobin Das, having secured 72.93. So one of the charges is that he selected a candidate having low merit, living certificate, which was the highest percentage of the marks among all candidates who had applied for the post. Sri Sharma, therefore, alleged to have violated provision so-and-so. I will not go to the details. Lordship will come to Article 2 at page 23. Sri D.N. Sharma, while functioning as so-and-so, GH Division Guwahati during the period 5/4/2010 to 17/4/2010, while holding the additional charge of so-and-so during the lead period of AC Das, Guwahati Division on 12th, 13, 15 CL and 16, which was later on modified and given to Sri A. High, Senior Postmaster, allegedly issued appointment letter to a candidate, namely Muhammad Iyazul Haq, son of Muhammad Pyar Ali, of village so-and-so, for the post of GTS BPM on 13/7/2010, white memo number so-and-so, on the letterhead of SSRM GH Division Guwahati. Sri Haq has been selected by him in the capacity of SSPO Guwahati, and he managed to keep a copy of the said appointment order in the concerned file of Zahirpur B.O. Sharma. See, Sharma was no more holding the charge. While he was not in charge, he manipulated an order and kept it in that file. Thus, D.N. Sharma allegedly issued an irregular appointment order selecting Muhammad Iyazul Haq to the post of BPM Zahirpur. Even while holding the charge of the current duties of SSPM Guwahati, he was not competent to issue the said appointment order. Let us see Article 3. That it's on the next page, Lordship, page 24. that Sri D.N. Sharma, while functioning as SSP of Guwahati Division from 31/12/2005 to 1/4/2010, alleged to have prepared a list of 3 candidates for interview for the post of GDS BPM Ukiam BO on 3/12/2009 as scheduled, while it is memo number so and so dated 26/11/2009. Sri Sanjeev Kolita, one of the above 3 candidates, was less than 18 years of age on the day of selection, and therefore Sri Kolita was not eligible candidate for the post of GDS BPM. But the said T.N. Sharma selected the candidate, namely Purnima Chaudhary, wife of Vasudev Kolita of village so and so, out of the remaining 2 eligible candidates, and appointed her white SSP of so and so against the post of GDS BPM without re-notifying the vacancy as per the provision laid down under the DG post letter dated so and so. Article 4 on the same page, Lordship will find.
So all these articles are regarding illegal and irregular.
Yes, Lordship.
Less meritorious persons.
Yes.
And rejecting the candidature of the more meritorious persons. These are the allegations. Yes.
Yes, Lordship. Now, he was only issued a charge sheet, Lordship. Now, without the conclusion thereof, the tribunal, only on the ground of
Tribunal has got the charge sheet mainly on 2 grounds. The delay of 4 years.
Yes, Lordship.
And another is whether those appointments which he has made, whether those appointments were cancelled or still.
Lordship, whether those appointments are cancelled or whether they are subsisting, that would be a different issue altogether. The petitioner, the applicant before the tribunal cannot take a plea that so and so has not been punished, therefore I should not be punished.
Ultimately, it's a
Yes,
relevant factor.
yes, Lordship.
Since we are saying that illegal and irregular appointments were provided.
Yes,
what
Lordship.
happened
Now,
to the appointment.
now, once the process of departmental proceeding goes ahead, it culminates into a positive finding, Lordship. Definitely action against the others will also be taken. Now, that process has been solved at the first instance itself.
Yes.
And the judgment, Lordship, I have just given a copy.
Yeah, that is there.
That is there, that has been followed in another judgment also, Lordship, is basically there. I'll give a copy, Lordship, of the other judgment also. Go to Rama Computer. 2013 6 SCC 5155. So it follows the first judgment, Lordship. Basically, on the legal issue, it is the same, Lordship.
Fine. Yes, Mr.
Malab, the basic 2 grounds that the tribunal has taken into account while setting aside the charge sheet.
Not only 2 grounds, only 1 ground for this 4 years delay. That's all.
No, the other factor has also gone into my lord. Has also
Which
been,
factor?
that is the fact that the appointees, the 9 appointees about whom, my lord, there is discussion in the charge sheet.
So ultimately, without there being any finding that there was illegality in appointing or selecting them, they can remove directly those persons.
No, I'm
Without
not.
the inquiry, that's why
I'm not.
they have
I'm not
conducted
saying
the
that.
inquiry. What would be the result of the inquiry? Then only we then proceed further in accordance with that.
My lord, the purpose of this inquiry is only to find out whether I committed a misconduct or not.
That's right.
Now.
And
the-
suppose
the-
if a finding comes, no, there was no misconduct and there is no illegality in this
No, my lord,
recruiting
my-
or selecting
my-
those
my-
persons, then without there being, without having the specific positive finding regarding irregularity in the selection, commission of irregularity or some whatever it may be illegality
My
in
lord,
selections, those services of those persons can be
My
terminated.
lord, I'll make a submission here, my lord. My lord, the illegality and misconduct are not synonymous.
Is there.
Misconduct,
Illegally, you have committed illegality, therefore you have committed misconduct. That is dependent on each other.
the charge sheet says that
Maybe in the inquiry, will be able to demonstrate that there is no illegality in this, the procedure which I have adopted.
Now,
Then-
in that case, my lord, before I address your lordship on the ground of delay, my lord, I'll first address your lordship on the point whether per se by appointing a less meritorious candidate, it can be said to be an act of illegality. Well, the basic ground that the charge sheet centers around is that by appointing a lesser meritorious candidate, by ignoring,
This is not the finding of the tribunal.
no, this is, my lord, the charge
This
sheet
is not the
says,
finding of the tribunal.
my lord, the charge sheet says that by appointing a less meritorious candidate,
Let the, this tribunal ponder over this issue. Let the tribunal ponder over this issue that simply because he has selected the less meritorious person, therefore it can't be a misconduct.
well, that the tribunal
This
has
is not
also,
the finding of the tribunal.
it may not have come into the finding, my lord, but the tribunal has also addressed the issue in one of the paragraphs, my lord, because the specific case that
Read which paragraph?
your lordship will, where, my lord, the tribunal has considered my grounds.
That is the contention he has recorded. Where is the finding?
No, my lord, there is a direct decision on this point. A direct decision of the Honorable Supreme Court saying that in the appointment of DDS,
After
Gramin
lunch.
Dak Sevak,
After lunch.
Plus subject to permission and indulgence of your lordship, my lord, and from the permission of my senior. One judgment, my lord, I just omitted to place in the morning hours, my lord. I have already informed my colleague appearing against me, my lord. Perhaps this will assist your lordship. my lord. I'll just mark the paragraph, my lord. A second.
Take it on record.
Paragraph mark. Yes, my code. Deeply obliged.
Yes.
my lord, I was just referring to the allegations, my lord. The allegation is with regard to the fact that more meritorious candidates were ignored and lesser meritorious candidates were granted appointment. And my lord, even before the tribunal, my lord, a case was placed, a direct decision of the Honorable Supreme Court on the point
Yeah.
that in case of extra departmental agents, just like the candidates who were selected here, my lord, merit is not the sole criteria. And therefore,
What if this argument is available to you in case they punished you, treating it as a misconduct? Then only you can raise this argument that this can't be treated as misconduct if I have selected,
No,
if I have selected less with meritorious person. Then also can't be treated as misconduct. That only in case when the finding is recorded that you are guilty of misconduct.
no, my lord,
Not at this stage, sir.
no, my lord, I challenge the charge sheet not only on the ground of delay. The charge sheet was challenged on very many grounds, my lord, amongst which, my lord, one of the grounds was delay.
Yeah.
The other grounds was that the alleged acts that the charge sheet constituted, they do not constitute misconduct at all. That was one of the grounds taken in the way.
In response to my senior's argument.
Let him complete.
Yes, yes, yes.
And my lord, I urge basically 4 grounds before the tribunal. Of course, my lord, the tribunal has given the
With only one ground.
only one ground, but the 4 grounds were urged. And these were namely the alleged acts complained of in the charge sheet, my lord. They do not constitute misconduct because of a certain decision of the Honorable Supreme Court. The second ground that was urged was with regard to the provision of pension rules. Because I am a retired employee now, so only thing they can do against me is to invoke Rule 9 of the CCS pension rules.
That is.
And my lord, there is a rider in the rule
Yeah.
that the incident alleged of the alleged misconduct should not be of a period prior to more than 4 years prior to the date of retirement. That was one of the grounds taken.
That would not come in this, sir, because their plea was that for the first time they detected whatever the irregularity, alleged irregularity in the year 2011.
Exactly.
The date of the knowledge, they,
No.
4
Well-
years period will start from the date of the knowledge.
My lord, exactly that contention was rejected by the Honorable Supreme Court in 2 cases, my lord. In 2 cases, my lord, I'll just submit that decision to your lordship, my lord. But before I take your lordship to the aspect of delay, my lord, what I am on is that the charge sheet was issued to me on 20th of February, dated 20th of February, 2015. The acts complained of were for the period from 2005 to 2010. And that is clearly beyond the period of 4 years from the date of retirement. That I'll just submit that, my lord.
Right, 4 years bar. Will it also come in when you are in the?
Yes. Yes, my lord, that is I'm showing to you, lord. My lord, that of course, my lord, this decision of the Honorable Supreme Court is in respect of the state government pension rules. But it is exactly perimeter to Rule 9 of the CCS pension.
And also the proceedings were initiated prior to retirement of people.
Yes.
Yes, I listen to conversation.
CCS rules permit continuation of the
CCS pension rules permits continuation. My lord, I'm just placing that before your lordship. If your lordship will kindly come to paragraph 3. My lord, this rule is perimeter with Rule 9. My lord, make see proviso, provided that in paragraph 3.
Just a minute.
Citation to you.
Citation to. INSCC. 395. 395.
Yes, Doctor, what do you want to?
Kindly come to my lord, paragraph 3 paragraph 3 of the judgment. Just after the lines provided that such departmental proceedings, if not instituted, that takes care of the situation, my lord, where the proceeding retires. If not instituted while the officer was on duty either before retirement or during re-employment, shall not be instituted save with the sanction of the governor. 2 shall be in respect of an event which took place not more than 4 years before the institution of such proceedings. Now, here in the case, my lord, the events were from the period 2005 to 2010. It may have come to their.
No, come to this judgment. Para number 2.
Yes.
We have heard the land council both the appeal, special appeal from the High Court of Constitutional. The admitted position is that before departmental inquiry was initiated against the respondent for his so and so on is attaining the age of superannuation, he was allowed to retire from service.
Yes.
So this is in relation to a person retired from the service and disciplinary proceedings were initiated against him after retirement.
Exactly,
Yes.
exactly. Now here
Then
is,
in case if what you suggest, if analogy is applied, then in no case, by 4 years have passed, the disciplinary proceedings cannot be initiated against any government servant.
my lord, may kindly
This is
come to
absolute-
paragraph 6, my lord.
Yes,
My lord, may kindly come to paragraph 6. It would thus be seen that proceedings are required to be instituted against a delinquent officer before retirement.
yes.
That is what has happened in my case.
Yeah.
It has been in my case. There is no specific provision allowing the officer to continue in service, nor any order passed to allow him to continue on re-employment till the inquiry is completed without allowing him to retire from service. Equally, there is no provision that the proceedings be initiated as disciplinary measure and the action initiated either would remain unabated after retirement. If Rule 351A is to be operative in respect of pending proceedings, this is important, my lord. By necessary implication, prior sanction of the governor to continue the proceedings against him is required. On the other hand, the rule also would indicate that if the officer caused pecuniary loss or committed embezzlement, etc., due to misconduct or negligence or dereliction of duty, then proceedings should also be instituted after retirement against the officer as expeditiously as possible. But the events of misconduct, etc., which may have resulted in loss to the government or embezzlement, that is the cause for the institution of the proceedings, should not have taken place more than 4 years before the date of institution of such proceedings.
That is in relation to after retirement.
No, my lord. I mean, may I just read it
But
once
the
again?
events of misconduct, etc., which have resulted in the loss to the government or the cause of institution of proceedings should not have been taken place and before that. Otherwise, the department must be instituted before the letter date of misconduct, etc. has been played. Immediately the case of the Sir, it is in respect of this. You can't read these lines in isolation, sir.
No, my lord.
You have to take into consideration the facts of the case also. Now, in other words, the departmental proceeding must be instituted before the lapse of 4 years from the date of eventual etc. had taken place. Admittedly, in this case, the officer has retired on that time. The proceedings were initiated on so and so. Obviously, the event of this caused primary loss to the state took prior to the 4 years from the date of retirement.
That is what I am.
From the date of his retirement.
Yes. Now, in my case,
Under these circumstances, the state has disabled
itself
by
their deliberate omissions to take appropriate action.
Allowing the officer to escape the provisions of the rules. The orders do not preclude proceedings investigating into offense taken thereof. Yes.
Now, I am making an alternative argument also, my lord. In the context of a disciplinary proceeding against a retired employee, Rule 9 permits continuation even after retirement. That is clear. But the Rule 9 can be invoked only in one eventuality, where the alleged acts of omission and commission constitutes grave misconduct or grave negligence. Now, what is grave misconduct and grave negligence, my lord? That is described in Rule 85B. Lordship may kindly have that rule.
85B.
85B. Sorry, my lord, 852. It will be 852. Here in this book, my lord, if your lordship is holding this book, my lord, yes, that there your lordship will find it in 852 at page 9. The expression grave misconduct. Huh? This is mentioned. Now, may I read it to your lordship?
So you mean to say that grave, if these are the eventually in these eventualities only grave misconduct will.
Well, the rule says so, my lord,
Rule says
and my lord,
grave misconduct includes. It's simply expand the, what is the scope of the term grave misconduct? It doesn't mean that except this, no other of act is to be understood as a grave misconduct. This is not.
my lord, even my lord, I'll just place one judgment of this honorable court also, my lord. My lord, where the Supreme Court's decision in D.V. Kapoor's case was referred to, and ultimately, my lord, the exposition that came out, that the permissibility, my lord, the eventuality is that the risk is only on the pension, withholding of pension either whole or in part. Now, this action of withholding pension either whole or in part, that will come only in respect of a case where, my lord, the finding is that the case involves a commission of grave misconduct. And what is grave misconduct, my lord? That is defined in.
Sir, finding, then where is the finding?
No, my lord, I am coming to it, my lord. Because my ground before the tribunal has been that even on operation of CCS pension rules, my lord, the charge sheet cannot continue against me. In this judgment, your lordship can see paragraph 11, my lord. And paragraph 2 is the finding, my lord.
Ultimately, again, this case is altogether distinguishable, where the inquiry was concluded and finding was there that this charge is true and this charge is not true.
No,
In your case, sir,
my lord, this judgment is also on the fact where the charges were proved. Correct, my lord. But the exposition of law, my lord,
only on this fact also, near, sir.
my lord, what had gone into with the court, my lord,
Yes.
that is the explanation 8.5. And explanation 8.5, my lord, the paragraph, if your lordship will kindly consider paragraph 12. Paragraph 12, my lord, as it can be seen from above, only those misconduct which affects the interest of the general public or security of the state pertaining to disclosure of secret information can be ground for invocation of power to deduct pension under Rule 9.1. Therefore, my lord, to permit continuation of a disciplinary proceeding, my lord, this Rule 9 will come into play. And if Rule 9 comes into play, automatically 8.5.2 or sorry, 8.5B, that gets attracted. And lastly, my lord, the question of delay. Now, the charges were pertaining to period from 2005 to 2010, and they said that they came to know about it in the year 2011. The question is whether it will run from the date of knowledge or it will have the effect from the date of commission of the offense itself. But I'm just placing a decision of this honorable, the Honorable Supreme Court, V. Mahadeva. Well, this exact submission was made also in this case. Your Lordship can kindly turn to paragraph 15.
Paragraph
15.
Yes.
After the 6th line, 7th line, it is now stated that.
Yeah.
It is now stated that the appellant has retired from service. There is also no acceptable explanation on the side of the respondent explaining the inordinate delay in initiating disciplinary proceedings. Mr. R. Venkatramani, learned senior counsel, is appearing for the respondent. His submission that the period from the date of commission of the irregularities by the appellant to the date on which it came to the knowledge of the Housing Board cannot be reckoned for the purpose of ascertaining whether there was any delay on the part of the board in initiating disciplinary proceeding against the appellant has no merit and force. The stand now taken by the respondent in this court in the counter affidavit is not convincing and is only an afterthought to give some explanation for the delay. Well, this exactly same submission was also advanced in that case. Under these circumstances, we are of the opinion that allowing the respondent to proceed further with the departmental proceedings at this distance of time will be very prejudicial to the appellant. Keeping a higher government official under charges of corruption and disputed integrity would cause unbearable mental agony and distress to the concerned officer. The protracted disciplinary inquiry against a government employee should therefore be avoided not only in the interest of government employee, but in the public interest and also in the interest of inspiring confidence in the mind of government employees. At this stage, it is necessary to draw the curtain and put an end to the inquiry. The appellant had already suffered enough and more on account of disciplinary proceedings. As a matter of fact, the mental agony and sufferings of the appellant due to the protracted disciplinary proceedings would be much more than the punishment for the mistakes committed by the department in the procedure for initiating the disciplinary proceedings. The appellant should not be made to suffer. We therefore have no hesitation to quash the charge memo issued against the appellant. There also, my lord, the charge memo was challenged on the ground of delay.
Yes.
Here also, your lordship will find, as far as the question of delay is concerned, my lord, there is absolutely no explanation in the written statement filed before the tribunal. The only statement that has come in the WS is that they detected the irregularities in the year 2011 and thereafter charge memo was issued in the year 2015. And that too, just 4 days before the person went on retirement. What had happened in between that is the period from 2011 and to 2015, the date of issuance of charge sheet, there is absolutely no explanation.
Is that a rejoinder on your behalf to that? What it meant?
That I'm not on record. But in the WS, my lord, there is except for stating as to when the period was, when the alleged irregularities were detected and when the charge sheet was issued, there is absolutely no explanation for the period of delay.
Yes.
Therefore, my lord, in the entire conspectus of the facts, although the tribunal has pronounced the order only on one aspect, my lord, these are also the attending facts and circumstances on which, my lord, the quashment of the charge sheet was sought for before the tribunal. And principally on the ground of delay, my lord, there is no explanation. So therefore, in my respectful submission, my lord, if the order of the honorable tribunal is viewed in the light of these attending facts and circumstances, my lord, there is absolutely no ground for interference with the order. That will be my humble and respectful submission.
Yes, Mr.
Lordship, so far as the first leg of argument of my senior is concerned, Lordship. Lordship will take note that the tribunal has passed the order only on the ground of delay.
Yes.
Whatever other things that has been submitted on merit by my senior, those were not the facts which were taken into consideration by the learned tribunal.
But these were reflected in the order. Reflected in the order, but
Lordship, what has been reflected is,
yes, I'm sorry.
what has been reflected in the order is, Lordship, is a part of some written submissions made by the council, and the judgments have been extracted therein. And the operative portion of the judgment of the order, Lordship, will find at page 91, paragraph 7. Therefore, nothing on merit has been considered by the learned tribunal. It only says in our considered opinion, in view of the charge sheet having been served after inordinate delay of 4 years and satisfactory explanation is not being given for the said inordinate delay for the alleged irregularities, no action for cancellation of the related appointments having been taken. No action for alleged appointments will come only after the charges are proved.
Yes.
Charge sheet having been served only 4 days before the retirement of the applicant, and in view of the allegations of omission and commission stated in the charge sheet being of procedural in nature, and thus in view of the law laid down by Supreme Court in Katina of decision so and so. But the learned tribunal has failed to take into account the citation which the CGC has placed before the learned tribunal. In fact, if your lordship, I have given a copy of 2013-6 SCC 515. That is
530.
Lordship, there is another 515. I have given two. There is one. There are two. There is one 530 and there is one 515 also. I have given Lordship. It is Lordship.
That is
Anant Kulkarni.
Anantan Kulkarni.
Yes. Lordship. Lordship, I may take your Lordship to paragraph 8 of that.
Yes.
If I may read, Lordship, I have just
Paragraph 8 of
Anant Kulkarni, Lordship. I have just made it bold just for your Lordship's convenience. If I may read, Lordship.
Yes.
The court tribunal should not generally set aside the departmental inquiry and quash the charges on the ground of delay in initiation of disciplinary proceedings. As such, a power is rehearsed the limitation of judicial review. In the event the court tribunal exercises such power, it exceeds its power of judicial review at the very threshold. Therefore, a charge sheet or show cause notice issued in the course of a disciplinary proceedings cannot ordinarily be quashed by court. The same principle is applicable in relation to there being a delay in conclusion of disciplinary proceedings. The facts and circumstances of the case in question must be carefully examined, taking into consideration the gravity, magnitude of the charges involved therein. The court has to consider the seriousness and magnitude of the charges, and while doing so, the court must weigh all the facts, both for and against the delinquent officers, and come to the conclusion which is just and proper. Yes, Lordship. Now, so far as Lordship, the initiation of the proceedings is concerned, Lordship has already noted the facts regarding the irregularities committed by the respondent pertaining to the year 2005 to 2010 came to the knowledge, came to light only on 24/2011. If my learned friend's submission that after 4 years, it cannot be initiated, Lordship will see when the charge sheet was issued. It was issued on 22/2015, that is before 4 years.
Yes.
That is before 4 years. Therefore, Lordship, the submission made by my learned friend that there is a limitation of 4 years, that goes. And in any case, Lordship has seen the charges. This particular officer has accepted applications beyond the date, prescribed date.
Yes.
Whether that is a small offense, Lordship.
Yes.
And the charges, Lordship, the learned member has taken note of in page 74.
Yes.
Second line from bottom, if other charges Lordship has seen. In article of charge number 4, it was alleged that he considered candidature of two candidates who had not submitted their applications and he received the applications of other candidates after the last date fixed. So that is the way, Lordship, the selection was conducted, Lordship.
Yes.
So far as the Lordship explanation to the delay, Lordship will see paragraph 5 of my written statement that your Lordship will find at page 68. And Lordship will read that with paragraph 7 of the petition. First, I take your Lordship to paragraph 5.
Yes.
That with regard to the statements made in paragraph 416 of the original application, the answering respondents beg to state that the proposal for disciplinary action was submitted on 29/2012, right? So and so for dated 29/2012 for the incidents during the period from 31/12/2005 to 2010. After thorough examination of the relevant record, memo of charges has been issued on 20/2/2015. Now, without the advice of the CVC, we cannot issue. There is, Lordship, I have explained that in paragraph 7 of my writ petition. And if I may read, your petitioners beg to state that with regard to the alleged delay, as observed by the learned tribunal, it is stated that the proposal for disciplinary action was submitted on 29/2/2012 2012 to the Director Vigilance, New Delhi, as the respondent belonging to Class 1 officer being appointed by the President of India, and the same was under consideration of the competent authority on the ministry. And finally, the charge sheet was served on the respondent on 20/02/2015 before his retirement, after being approved by the President of India. It is stated that ex post facto first stage advice of CVC was also obtained by OM dated 5/5/2015. It is not a case of a lordship or directorate or a department of a state government where the principal secretary will simply issue a show cause notice, lordship. It does go through a process.
Yes.
That is my humble submission.
Well, may I just missed out placing one decision, my lord, may I just place it? It is already quoted in page 14 of my 14 of
What
the.
is this then about?
Well, my lord, regarding the comparative assessment of comparative merit. 2007 SSC, my lord, it is already quoted in paragraph page 14 of the writ
Compared to
petition.
merit?
Yes, that more meritorious candidate does not automatically become the person.
This question again, we would like to say that this question will come.
Yes, that is true, my lord. But
That is then why should we go into all this?
it is already available in paragraph 14, my lord. I am just submitting the full citation, my lord. Page 14 of the writ petition, it is already available. The relevant paragraph will be paragraph 14, 15, and 16 in this judgment.
Yes.
So far as his contention in paragraph 7 of the writ petition is concerned, my lord, this was never before the tribunal. This has come for the first time in the writ proceeding, and that too without any particular.
Or is the
Obliged, my lord.
arguments concluded or is the?
Item 14.
Again, your senior is not here.
Yes, Lordship, I'm praying for an adjournment.
All right.
Yes.
Item 15 to 17.
My lord, this is an exercise matter, my lord. We are a tea state, my lord. We are a tea state, my lord, and we are procuring coal, my lord, for fuel. Cal sir is there. He's not here. I have not seen him today in the board.
He's not here. I think so. We have not seen him from morning. Yes.
Item 20.
Date, ma'am, fix, ma'am.
Date, whatever.
Well,
May it please your lordship. May I please, your lordship. In this matter, your lordship, learned AAG is Sikkim is to appear. But on the last night, I think that the respondents have informed him that they will be praying for some accommodation today.
Obliged, lordship. Item 21.
May I please? So your services were terminated way back in the year 2018.
No, it was terminated, the order was challenged. Now it was terminated by order dated 9/8/22. This is the imping order,
9/8.
22. And private respondent, after this order imping in this appeal, they have appointed the private respondent in my place. Here in my lord 2009, 10/9/2009, advertisement was issued. I was appointed as worker in 23/12/2009.
Yes, Mr. Ahmed. There is a finding recorded by the double single judge, para 70, that you had contended that you had applied for some other.
It is in the imping order, the order imping in the writ petition, it is reflected that it is my contention. I stated before the officer that I have applied in 2 posts. And this honorable court, the honorable single bench, to ascertain this fact, that was denied by me, that never such contention was made by me. And in order to ascertain this fact, whether it is correct or not, record was called for. And it is reflected in the order imping in this writ petition that no, there is no such record that only one. And the application,
Then why did you refer to the 16/6/2012 notification?
this is my alternative argument.
So you don't figure within the coverage area of the.
No. This is my final last Lego argument that even if the first argument is that my case was I am trying to buttress my case on two aspects. First, my name and the private respondent name appear in the same areas voter list.
Voter list is.
Yes, same areas. Your Lordship, this is my contention. That was not answered in this order impugning my name. And this fact was not denied. This was my first contention. I have annexed this voter list. Same place, same ward number, etc., only serial numbers are different.
But in the survey report,
There, exactly, this survey report I have disputed. Your Lordship kindly,
that can it be going to that in a repetition?
paragraph 8 of my, yes.
How can that be? I mean,
My case is that this survey report, the so-called survey report, they are saying it is expert survey report.
what is against you with the direct 3 times rejected
Yes.
on that point? The disputed question of fact, how can we now go and?
Now, therefore, my lord, for a moment, your Lordship kindly peruse the order impinging on the writ petition.
Okay.
That is page 72. It starts from 71 and relevant portion is 72.
Yeah.
I'm referring whereas in pursuance to the above order, District Social Officer such and such directed to inquire into the residential status of such and such under such and such. Peruse the inquiry report. My contention is that what is the manner of contacting this? Inquiry was conducted. I don't have any information. I was never taken into consideration.
What is the material in support that you fall within the coverage area of Sunarigaon, Anganwadi?
Yes.
What is the?
That I have given, my lord.
Your voter list will not, you will have to have a certificate from the counter
Yes. All documents I have annexed.
at that time.
Yes.
Documents are
The-
2010, 11, 12, 13.
Yes, in the writ petition is annexed.
Which you submitted along with your application.
Yes, your lordship will find the writ petition, copy of the writ petition. Page 56 to 63.
What was the advertisement?
Advertisement, it is in the 112.
112?
Page 112.
Ten 9/2009.
Yes.
Now come back to page 53. Fifty-seven.
This is 2012.
12,
Yes.
right? 58, 2000.
Well, this is 4912. Yes.
Okay, 12. Then 62, page 494.
17.
And you come to the advertisement.
9. All those.
Counsel, at the time of your application, what documents? you have
All original were
along
submitted in
with
the record.
application
Record was
that
with
you are
them.
the resident of that Sonalipur or Sonepur?
Yes, they were satisfied.
Where are those documents? Show us.
All documents, these are the documents I have submitted with them. My lord, record was called for. And record is with them. Record was called for and record is with them. Now, my lord, here, my lord, your lordship.
You have to please, you have to satisfy us that you have filed these documents on the basis of this. You are the resident of that area. Show us.
This is my predicament, my lord. Those documents who were
This is
submitted.
your predicament that at that time in the year 2009, you have not been able to prepare such documents which you have prepared thereafter.
But
This is your predicament. Yes, we understand that.
on the basis of what they have appointed me.
That's why it was under challenge.
Yes.
That's
Your
why
lordship kindly
there
peruse.
was
I
no
have filed.
basis- There was
Thereafter, what
no
happened?
basis for your appointment. That's why that was under
Your
challenge.
lordship kindly peruse one aspect of the matter.
Yes.
The entire stand of the government official respondent is there. The survey report was conducted, and during inquiry, my name was not found in the survey register. This is their contention.
That you please.
In the read.
Okay, please now come to page 113.
Yes.
These are the terms.
This is the condition.
Terms and conditions. Just a minute, please.
My
Let
lord.
us complete the query.
Yes, yes,
I did
yes.
not ask you. The Anganwadi worker, a Anganwadi helper are non-payable volunteer. Read.
My lord.
Please go through it.
The candidate must be local
Local area of
area
the
of the
subject
subject center.
The
The candidate issued by the Gaubula or ward member and president of Gau Panchayat should be attached to the application.
Show us that certificate. That's all. Will
Yes, ma'am. This is
immediately allow
that is I am submitting that those documents in original I have submitted.
Where is that?
And my
Copy?
lord,
Okay, show us a copy of that.
copy not with me, my lord, because it is in the record. Therefore, record was called for. Therefore, record was called for.
Is, don't step this up to
That,
this
my
level.
lord,
A person having a resident area certificate and is not having that copy.
therefore, subsequently, I have, by the same person who earlier issued, they again issued this certificate. But your lordship kindly,
Okay.
I may be
then
allowed.
Again, in the year 2012, if they have issued, is there any reference that we have already issued a certificate of residence in the year 2009 and now again we are issuing this duplicate or whatever it may be?
There is no answer. One matter I may be allowed to place before your lordship. Therefore, the contention is that in the survey register, my name is not found to be there. So, my husband, while during pendency of this writ appeal minor, file RTI application. In this RTI application, they have given copy. I have filed additional affidavit with the permission of this court, my lord. And in this affidavit, I have annexed the document. Your lordship, for a moment, kindly peruse this document. Page 144. This is a copy of resolution.
What is it?
Page 144, my additional affidavit, my lord.
Yeah.
Annexure A. Copy of resolution. And next is the marks, Annexure B.
Read, what is the resolution?
In today's meeting, the field inquiry report submitted by member secretary of the selection committee in terms of resolution accepted in the meeting dated 1/8/12 in respect of Gitanjali Kolida Anganwadi worker of Sunariga Anganwadi Center was examined. In the report, which was mentioned that Sunariga Anganwadi Center is located in the revenue village of Gasbari under ward number 8 of Morigaon town. Sunariga is a helmet of Gasbari as mentioned in the report. The house of Gitanjali Kolida was initially located at a distance of 500 meters because at the point of time the Sunariga Anganwadi Center was temporarily running on a boundary of village Gasbari and Sunariga. It is also mentioned in the report that at present, since the center has its own house, the center is situated at a distance of 700 meters from the house of Gitanjali Kolida. It is also mentioned in the report that the center is at a walking distance of 10-12 minutes from the house of Kolida. The house of the petitioner Vibha Goswami, that is the private respondent, is situated at Shunarigao. The local Gaubula submitted report in this respect during the time of local inquiry. Next, today's meeting, the merit list prepared in terms of interview held the appointment of Anganwadi worker in 2009-10 was examined. During such examination, it was found that name of petitioner Vibha Goswami appearing in third position in the merit list. On the other hand, Gitanjali Kolota is discharging her duty as Anganwadi worker comfortably, and also she has undergone job training of Anganwadi worker. It is also to be mentioned that Srimati Gitanjali Kolota at present discharging her duty as. So as regard merit, this is admitted fact. My position was first and private respondent third. And now, my lord, they have said my name was not there in the survey register. I have annexed the RTI document furnished to my husband on the basis, this document, page 149.
Yeah.
149 is the name, my lord, house number 44. Second, house number 44. This is the name of private respondent against house number 44. And the below, just below, house number 87, Noran Hazarika, Gitanjali Kolita, Nihar Hazarika. My name appears. So, but they said in the survey report, survey register, during inquiry, survey register, my name is not there. So after filing this additional affidavit, this honorable court by order dated 25/1/24 passed an order directing the respondent authority to reply this. They have filed affidavit, they have not mentioned anything. In their reply affidavit, your lordship kindly peruse what they have said. Paragraph 5.
Yes.
Court order is to file reply. They have not stated anything except, my lord, requoting their stand earlier in affidavit and opposition what they have filed. The same thing, whatever they, paragraph 1, page 173, my lord, paragraph 5. Both are the 9?
Yes.
Page 173, my lord, paragraph 5.
Yeah.
In terms of order, they are supposed to, my lord, file reply. But what they have stated, my lord, with regard to the statement made in paragraphs 3 to 6 of the additional affidavit, the deponent begs to state that in view of the Honorable Guwahati High Court order dated 2011, passed in 471 WBC, Vibha Goswami versus so-and-so, Director Social Welfare Assam issued order dated on the basis of inquiry report. They are, my lord, the same stand, the same thing they have stated in their opposition, filed in the writ petition. But they have not given any reply as to whether the RTI document, what happened, what about the RTI report?
Yes.
So this is my case, my lord. And the learned single judge has held, I have given sufficient opportunity of being heard. Your lordship has perused already. Only one word used. We have heard the petitioner. The manner I have categorically stated in my all the document I have produced before them. And two things, they have on the two ground my case rejected. One, I was found applied in two different posts. That was, my lord, proved to be false. Because document were called for, record were called for, record shows this statement is apparently false. I have only applied for one post. And the next thing only hard. If your lordship's consideration that mayor using the word hard is enough to terminate somebody from his post, who she is enjoying since 2009.
Yes.
I leave it to your lordship, my lord, to consider. 150. 150. One 115.
What time? Survey. It particularly.
This is the document furnished to my husband on the basis of RTI application.
It pertains to which village?
Ward number 8, this is Morigao, so ward number 8 is there.
It's not a Gram Panchayat.
At the earliest point of time, it was, no, now it is not, it is now under Morigao town.
So this correspondence corresponds to which? Earlier.
That is not, they will clear that. But this document, this is ward number 8 is, they are in my application also, in my address also, everything is there, ward number 8.
Now, page 164.
This is 2481.
That's an affidavit filed by the response number 6.
Yes.
Now, here if you come.
Again, ward number 8 is there.
No, okay. You come. Anganwadi Kendra. Punarika, right?
Yes,
Anganwadi Kormi, Itanjali Kodimi.
yes.
Now you see the Onsol,
Onsol,
Punari.
Kunari.
You are not from Punari. You are from Gas.
That I have categorically stated, Gasbari is a hamlet of Sunarigao.
Or it's the other way. Punarigam is a hamlet of which is correct.
I have categorically stated, my lord.
You had said,
No, I may be wrong, my lord.
you said.
Just, I have given the center detail.
He is the hamlet of the revenue.
In my affidavit in reply, I have stated. Reply of government, page 98. Page 106, my lord. 106. Four A of my affidavit in reply to the affidavit of the private respondent. Paragraph 4A. That the number 4 Shunariga Anganwadi Center, which was notified as was number 8 go in the aforementioned advertisement, is located in ward number 4 old, 8 new of Morigao town, and not located in any revenue village. Shunarigao is a given name of the center, and there is no any revenue village as such, namely Shunarigao in the Morigao district. The ward number 8 of Morigao town was constituted covering 3 revenue villages, namely Gasbari, Fulbari, and Kollanpur, wherein the concerned Anganwadi center is located. Shunarigao was a hamlet of erstwhile revenue village Gasbari, now under ward number 8 of Morigao town. Now, B is also relevant, my lord. After extension of Morigao town, including aforementioned 3 villages, namely Gasbari, Fulbari, and Kollanpur, within its area of operation, the area of petitioner's locality has been commonly known as Gasbari, although Gasbari has no physical existence at present as a revenue village, as the same is in ward number 8 of Morigao town now. The deponent mentioned her address as Gasbari, ward number 8, Morigao town, under 24 Shunariga Anganwadi Center area, post office Morigao, district Morigao, for communication. For avoiding inconvenience communication, the detailed address of the deponent goes to so that without any doubt that she is a resident under ward number 8 of Morigao town, where the Shunariga Anganwadi Center is located.
Yes. Yes, ma'am.
Let's see, I'm appearing for the private respondent, let's say respondent 6. Let's see the appellant who stated the certificates annexed to the writ petition, that is page 56 onwards. Although appellant has stated that those are residential certificate, but nowhere the certificate, it is mentioned that the petitioner appellant is resident of Sonarigao. Let's see, may kindly peruse those certificates. Let's see.
If the property
Let's see.
covers
Let's see.
area where he is,
Let's see. Let's see.
why will he not be within that company? That is what we want.
No, let's see the terms and conditions, let's see. As let's see mentioned. Let's see.
His house
Lordship.
It is not covered by your, that much.
That's it. Condition is that the candidate must be of local area, Lordship.
That's what I'm saying.
Lordship.
Local area,
Lordship.
that center is here.
Lordship.
And till your house coverage is there, till where you are standing.
Lordship.
If you are standing there within the coverage, you are within locality.
No, Lordship, Gasbari, there is another center, and Sonarigao, there is the.
Where is
Lordship,
that meeting?
Lordship, page 112, Lordship, advertisement say. Down below, Lordship, page 112. Morigao town. One that is Fulbari Kallanpur, that is one name of the center. Then 23-8B, Gasbari Fulbari, that is another center. And 24-8O, that is Sonarigao. That is a center in question, Lordship.
And he had applied as per the honorable
Lordship.
19.
As per record, the submission of the respondent number 2, that is not correct, Lordship. Although in the impugned order, it is stated that the petitioner has stated before the authority that she applied for
Sonarigao.
Lordship.
And
And it seems that Gasbari, Fulbari, there is one Anganwadi.
Yes.
2 centers covering your area.
3 center in what number 8?
So
center is altogether different, sir.
coverage. Which center coverage your,
That is, my lord,
all the 3?
no, Sonarigao.
Why not Gasbari? Gasbari is the village.
Lordship.
And now 3 center, I have already, my lord, led to your lordship the page I have said. It is now under town. Earlier, the name, these are the given name of a particular center only for.
Number 8, you are resident of which part?
That is 3, that is C. What number C? 8C, Sonarigao.
And in your that survey report, it says only Sonarigao and number. It does not say. Is 8A and 8B 2 different words?
8, main word 8, A, B, C, 3 on center. In under word number 8. And it was their contention that
Yes.
Lordship, may kindly peruse the annexure B to my affidavit in operation filed in the writ appeal against additional affidavit, Lordship, page 169, Lordship. That document I have procured by filing application under right to application and right to information act, Lordship. 169 last.
Yes.
Lordship, this was done after the issuance of order in the earlier writ petition, Lordship. This order is dated 22nd September 2011, Lordship. There is district social welfare officer. He undertook an inquiry, Lordship. May I read, Lordship? With reference to the subject cited above, I have the honor to state that I have locally inquired about Srimati Gitanjali Kolita, whether she is belong to the 24 number Sonarigao Anganwadi Center area under Bhubandha ICDS project or not. I have verified all available relevant records of the center. After going through the survey register, it is learned that Sonarigaon Anganwadi Center is covering an area having 367 population. But her name is not found in the survey register. I have physically verified the house of Srimati Gitanjali Kolita, the selected Anganwadi worker. Her house is not situated.
This document was on record in the earlier proceedings. So
Yes.
this document.
No, this is not filed as annex, Lordship. It was in the Lordship.
No, earlier 2010 when you approved this code.
No, Lordship.
And there are like,
No,
this was.
this document was not there.
No, no, this document is of 2011,
2011,
but you
but-
got it.
Lordship.
In their, in
And,
affidavit in opposition filed by government,
Mhm.
it is categorically stated. And my case, your lordship, for a month, page 74, we start from page 76. That inquiry report submitted by DSO Morigao, paragraph 4, revealed that the name of Gitanjali Kolita is not found in the survey report. Page 78. On the basis of inquiry report next 79, District Social Welfare Morigao by letter dated such and such dated 22/9/11. This is the same letter my friend is referring to. Here, against this, my pleading is the, your lordship, for a moment kindly, what was my pleading in the read petition? Page 33. 34, man. Paragraph 8. From middle, my lord, I am saying. The so-called survey report, my lord, got it. The so-called survey report relied upon by the respondent to in passing imping order dated such and such was never been communicated to the petitioner. Therefore, the petitioner had got no opportunity to challenge the said survey report. The petitioner categorically denies that there was any such survey conducted by the respondent number 3 to ascertain the residential status of the petitioner, as stated in the imping order dated such and such. Hence, the petitioner disputed the correctness of the so-called survey report and accordingly challenged the legality of the same. She has no knowledge about any such survey stated to have been conducted by respondent number 3. The petitioner was never asked by the respondent number 3 to participate in the survey or submit document evidence in respect of her residential status. If at all any survey was conducted by the respondent 3 as stated in the imping order, the same was conducted ex parte behind back of the petitioner. So this is my categorical stand. And on this, my lord, I was relying upon.
May I submit one thing? Lordship, the survey conducted at that time, Lordship, it was alleged that the petitioner appellant was not informed. The survey conducted by each and every Anganwadi center, covering the area under which it works, Lordship, the center. So under that area, the residence of the appellant does not exist. So how the appellant will come to know about the survey?
What is the distance between your house and the?
Yes, I don't have that. That's it. I am
Between your house and the appellant's house?
that's it. Actually, I am legal aid counsel here. That's it. I don't have personal knowledge. And the survey is the. One more thing, survey register is annexed in the additional affidavit that is prepared during her service period, let's say.
Close for orders.
That's it, of that.
I am obliged.
Leftover item 10.
May it please your lordship. Your lordship, my lord, appellant was enrolled as Assam Rifle, my lord, on 2010-1981. But in the year 1992, my lord, when he was in government duty, my lord, he met with a road accident, my lord. For then, my lord, he
Why
got
you have approached court with the delay?
delay, my lord. Earlier also he has approached, my lord.
Well, then at that time in Delhi High Court, you approached, you have not raised any such plea
Yes,
regarding disability pension.
Yes, my lord.
You were compulsory retired, you accepted the pension happily and thereafter turn back and come again before this court. How can it be?
My lord, but the fact is that, my lord, it is a fact that he
Then
got.
why, if the fact was that, then why you have not pleaded earlier?
My lord,
Either
he,
before the Delhi High Court or before this court.
yes, my lord, but fact is that, my lord, he got injury during government
Madam,
duty.
but this is also fact which we are mentioning.
My lord, I hear he is praying for pension, my lord.
Pension, compulsory retirement pension you are getting.
That is, I am getting, my lord. In addition to that, yes, because, my lord, I got seriously injury and my body parts was removed, my lord,
Seriously injured in which year?
in 1992, my lord.
1992.
In
And you approached this court for this disability pension in the year
Here, my lord, in 2012.
2012. So who knows in between 1992 to 2012, when you were not in service of this respondents, you have received this injury in what, where? And you refused for that. You refused for that medical examination also.
My lord, the thing is like that, my lord. I thought as soon as I receive, my lord, medical document, I will be discharged from service. I prayed for the department.
Without there being any medical report.
My lord, medical board report is there, my lord. Next, kindly see page 40, my lord.
Yeah.
Yes, my lord. 40 and XR1.
Yeah. So it says what?
Says, my lord, that my disability was, my lord, I was placed low medical category. All these documents are there, my lord. Medical board proceeding was.
Then how the learned single judge observed that he refused for this medical examination?
That is, my lord, I think for percentage of disability.
Then without there being any assessment of the percentage of disability, how this pension can be granted?
My lord,
So your disability was 20%, 40%, 60%, or 10%?
my lord, my documents are available in the department also. Today also I am ready, my lord.
Madam, how can it be?
But my lord, law, as per law, I am entitled. That is my submission, my lord. Maybe percentage at that time he may not be aware, my lord. But fact is that he got injury, his body parts was removed, my lord.
That fact is not proved, madam.
No, page 40, my lord, all medical documents.
Anything else?
My lord, I am relying some OA, my lord, of this department, my lord, where, my lord, they say
Wherein the person has refused for medical examination and voluntarily accepted the compulsory retirement pension. In that case also, the OA said, "Yeah, no, you have to give him a disability pension."
My lord, I refuse because, my lord, one medical officer detained me, my lord. That is also a fact, my lord. That's why I refused. to get and I was given pressure
Okay,
to
madam, we'll
accept.
consider. Pass and.
Just one thing I would just like to point out. The medical report that she is relying upon is of 1995. That is, she suffered an injury. She has been out of service in 1999.
He or she?
Oh, I'm sorry.
Yeah. You are changing the gender.
Lordship, it so happened my Honorable Justice Nair would know. First day, he was in the CAT. He faced a situation. The next day, I went to the CAT. And that was the situation. First day, I was told that you have to assimilate yourself with your client. He faced the same thing. I faced the same.
My lord, may I pay these two OMs, my lord?
No, OMs are not binding on this court.
And also CCS, as per CCS pension rule, my lord, I'm entitled.
So, obliged, Lordship.